A very good morning to our esteemed dignitaries, respected faculty, and dear participants. On behalf of the Karnataka Institute of Law and Parliamentary Reforms, in collaboration with the School of Law, Christ, deemed to be University, Bangalore, I extend a warm and heartfelt welcome to each one of you to the National Seminar on Strengthening Human Rights, Intersectionality, Accountability, and Inclusive Rights in an Evolving India. The Karnataka Institute for Law and Parliamentary Reform, KILPAR, was established in 2005 under the Department of Law, Justice and Human Rights, Government of Karnataka, following a state cabinet decision. To ensure autonomy, it is registered under the Karnataka Societies Registration Act 1960. The Governing Council, with the Chief Minister as President and the Law Minister as Vice President, oversees its functioning. KILPAR focuses on law and parliamentary reforms through research, drafting legislation, legal awareness, and training. It has published 85 research-based books, conducted over 300 seminars on socially relevant legal topics, and organized model legislative assemblies at zonal and state levels, including exclusive sessions for women. Additionally, it provides training for government advocates and prosecutors. Committed to its objectives, KILPAR continues to expand its initiatives with innovative programs. The School of Law, Christ, deemed to be University, established in 2006, is committed to nurturing socially responsible and professionally competent legal professionals. With a strong focus on academic excellence, research, and holistic development, the School of Law has emerged as a leading institution in legal education, fostering a culture of justice, equity, and inclusivity. We have received multiple paper presentations from various institutions, including national law universities, from which 60 paper presentations have been shortlisted. Today, we come together to deliberate on the crucial issue of human rights, to share knowledge, and to explore inclusive and accountable frameworks in an evolving India. The Mike Maestros team of the School of Law presents today's seminar, and I am Dia, and I will be your host for today's seminar. To commence today's proceedings, we begin with the traditional lighting of the lamp, a symbol of wisdom, knowledge, and the dispelling of darkness. I now invite Dr. Valarmati R., Professor, School of Law, Christ, deemed to be University, Dr. Sapna S., Dean in Charge and Head of Department, School of Law, Christ, deemed to be University, Dr. Shibu P., Associate Head of Department, School of Law, Christ, deemed to be University, and Dr. Chaitra R. D., Associate Professor, School of Law, Christ, deemed to be University, to come forward and join us in the ceremonial lighting of the lamp. We request Sinchana Acharya to render the invocation song. We request the dignitaries to kindly go near the lamp.
ಶರಣು ಶರಣಯ್ಯ ಶರಣು ಬೆನಕ ನೀಡಯ್ಯ ಬಾಳೆಲ್ಲ ಬೆಳಗುವ ಬೆಳಕ ಶರಣು ಶರಣಯ್ಯ ಶರಣು ಬೆನಕ ನೀಡಯ್ಯ ಬಾಳೆಲ್ಲ ಬೆಳಗುವ ಬೆಳಕ ನಿನ್ನ ನಂಬಿದ ಜನಕ್ಕೆ ಉದಯ ಎಲ್ಲ ಸುಖ ತಂದೆ ತಾಯೋ ನಮ್ಮ ಕರಿಮುಖ ಶರಣು ಶರಣಯ್ಯ ಶರಣು ಬೆನಕ ನೀಡಯ್ಯ ಬಾಳೆಲ್ಲ ಬೆಳಗುವ ಬೆಳಕ ಎಲ್ಲರೂ ಒಂದಾಗಿ ನಿನ್ನ ನಮಿಸಿ ನಲಿಯೋದು ನೋಡೋಕೆ ಚೆನ್ನ ಎಲ್ಲರೂ ಒಂದಾಗಿ ನಿನ್ನ ನಮಿಸಿ ನಲಿಯೋದು ನೋಡೋಕೆ ಚೆನ್ನ ಗರಿಗೆ ತಂದರೆ ನೀನು ಕೊಡುವೆ ಬರವನ್ನ ಗತಿ ನೀನೆ ಗಣಪನೆ ಕೈ ಹಿಡಿಯೋ ಮುನ್ನ ಶರಣು ಶರಣಯ್ಯ ಶರಣು ಬೆನಕ ನೀಡಯ್ಯ ಬಾಳೆಲ್ಲ ಬೆಳಗುವ ಬೆಳಕ ನಿನ್ನ ನಂಬಿದ ಜನಕ್ಕೆ ಉದಯ ಎಲ್ಲ ಸುಖ ತಂದೆ ತಾಯೋ ನಮ್ಮ ಕರಿಮುಖ ಶರಣು ಶರಣಯ್ಯ ಶರಣು ಬೆನಕ ನೀಡಯ್ಯ ಬಾಳೆಲ್ಲ ಬೆಳಗುವ ಬೆಳಕ, ನೀಡಯ್ಯ ಬಾಳೆಲ್ಲ ಬೆಳಗುವ ಬೆಳಕ, ನೀಡಯ್ಯ ಬಾಳೆಲ್ಲ ಬೆಳಗುವ ಬೆಳಕ.
The participants may use the back gate to move in and out of the hall. I now invite Dr. Valarmati R., Professor, School of Law, Christ Deemed to be University, to deliver the welcome address.
Good morning, one and all. I extend a warm welcome to all of you on this momentous occasion. It's my profound privilege to extend a heartfelt welcome to the National Seminar on Strengthening Human Rights, Intersectionality, Accountability, and Inclusive Rights in an Evolving India. We have gathered here today not just as an academics or professionals, but as custodians of India's constitutional ethos, a living promise etched in the preamble from justice and liberty to equality and fraternity. It's my privilege to introduce and welcome our today's chief guest, Srimati Nerale Bhavani, Principal Secretary, Department of Law, Justice and Human Rights. Madam graduated from NLS and was appointed as Additional District and Session Judge on 8/6/2015 and worked at Mangalore, Bellary and Bangalore as Additional District and Sessions Judge. In the month of May 2023, Madam was designated as Principal District and Session Judge at Chikbalapura. Now, Madam is working as Law Secretary. I, on behalf of Christ University School of Law, extend warm welcome to you, Madam. It's my honor to introduce and welcome our today's guest of honor, Shri S. K. Ventigodi, Member, Karnataka State Human Rights Commission. Sir has enrolled as an advocate in the year 1986 and practiced at Saundatti for about 6 years. Sir was selected as Munsif and Magistrate in the year 1993 and served at Kaustagi, Basanabagegawadi and Shigawa. Sir was promoted as Civil Judge, Senior Division in the year 2003 and served at Mysore, Srirangapatna and also in Lokayukta office. Sir was promoted as Ad hoc Session Judge in the year 2009 and served in City Civil Court, Bengaluru till 2013, and during this period disposed of several high-profile sessions cases, including the case of famous fiancé murder case, also known as Shubha murder case. Also served as Additional District Judge cum Presiding Officer, CBI Court, Bengaluru, Labour Court, Family Court and Industrial Tribunal at Mysore. Sir was promoted and served as Principal District and Session Judge Mysore from March 2018 to May 2020. Sir served as Registrar, Karnataka State Administrative Tribunal, Bengaluru from May 2020 to June 2022. Sir superannuated on June 30th, 2022. Sir was again appointed as Registrar, Karnataka State Administrative Tribunal for one more year till August 2023 on contract basis. Now, Sir is serving as member, Karnataka State Human Rights Commission, Bengaluru since 29/11/2023. Sir, on behalf of Christ University School of Law, I extend a warm welcome to you. It's my privilege to introduce and welcome Dr. C.S. Patil, Chairman, Karnataka Institute of Law and Parliamentary Affairs, Kilpar, Bengaluru, who will be presiding over today's national seminar. Sir graduated from University of Mysore in 1983. Sir moved over to Dharwad to pursue his studies in law at the University College of Law. Sir completed LLB in 1986, obtained his master's degree in law from University of Mysore in 1988, specializing in constitutional law. Sir secured first class and first rank at LLM for which he was awarded 2 gold medals and a cash award by the University of Mysore. In addition, the government of Karnataka has awarded him a cash prize for securing first rank in LLM. Sir holds a doctorate in law from Karnataka University, Dharwad. Sir has taught for over 3 decades at JSS Law College, Mysore, HLA Law College, Dharwad, KLE's Law College, Bangalore, University College of Law, Dharwad, and KSLU's Law School. Sir was a professor at KSLU, Hubballi, Karnataka, and discharging responsibility as head of the Research Center for Democracy and Constitutional Government. Sir has discharged responsibilities as Dean, member of Syndicate, Academic Council of KSLU, and Director of KSLU Law School for 7 years. Sir has written 1 book, edited 4 books, and more than 85 articles in law journals. Sir has an expert to submit a research paper to the Committee on Reforms of Criminal Justice System, of which Honorable Dr. Justice V.S. Mallimath was the chairman. Sir has drafted many legislation for the government of Karnataka, including Karnataka State Human Rights Court Rules 2006. Sir has received recommendation for his work in the field of human rights in 2010. Sir was a member of Expert Committee for Establishment of Karnataka Rural Development and Panchayat Raj University. Sir evinces a lot of interest in curricular, co-curricular, and extracurricular activities and has actively involved in legal aid, legal literacy activities for more than 25 years. Sir is presently serving as a director of KILPA. Sir, on behalf of Christ University Institute of Law, I extend a warm welcome to Dr. Ravaya Odeya, Research Head, Parliamentary, Karnataka Institute for Law and Parliamentary Reforms. And I would also extend a warm welcome to all the resource person for plenary session, Dr. Sudesh V, Senior Professor and Dean, University Law School, Law College, Bangalore University, Dr. Akila Basali, Professor of NLSU, Dr. Priya Vardarajan, Chief Executive Officer, Durga India, Sneha Priya Yanappa, Team Lead, Vidhi Karnataka Vidhi Center for Legal Policy, Dr. Manjari Subin, Professor School of Law, Christ University, Jyotika, Senior Fellow, Judicial Reforms, Vidhi Center. And I would extend my heartfelt welcome to our Dr. Sapna HOD, Associate Dean, Dean in Charge, School of Law, who is our constant support for all our endeavors. I welcome them. I extend warm welcome to all the participants and paper presenters. Welcome to the National Assembly. Thank you.
I now invite Srimati Narade Veerabhadraya Bhavani, Principal Secretary, Department of Law, Justice and Human Rights, Government of Karnataka, to deliver the inaugural address.
Very good morning. Respected Honorable Shri S.K. Mantigodi sir, Member, Karnataka State Human Rights Commission. Respected Professor Chidananda Reddy S. Patil, Director, KILPAR. Respected Madam Dr. Sapna, the Dean in Charge and Head of Department, School of Law, Christ, on the dais, and all the other dignitaries of the dais, and my dear students. So today we are here to speak on human rights, and also you are going to have a seminar. So human rights are the fundamental rights and freedoms inherent to all human beings regardless of race, sex, nationality, ethnicity, language, religion, or any other status. These rights are universal, inalienable, and indivisible. In India, we have an enactment for the better protection of human rights and other connected matters called the title called Protection of Human Rights Act of 1993. Section 2D of the Act defines human rights as a right relating to life, liberty, equality, and dignity of individual guaranteed by the Constitution or in international governance and enforceable by the courts in India. So, though our Constitution does not expressly use the term human rights, but Part 3 of the Fundamental Rights speaks about the essential guarantees to the citizens, justice and individual development. These fundamental rights are enforceable through the court of law. Article 14 to 18, we all know that, talks about equality before the law, prohibits discrimination on the ground of religion, race, sex, caste, or the place of birth and guarantees equality of opportunity in the matters of public employment. Article 19 to 22 encompasses various freedoms such as speech, expression, assembly, association, movements, residence, and the right to practice any profession or occupation. It also includes right to life and personal liberty, protection against the arbitrary arrest and detention, including the right of the prisoners. So, Article 22 and 23 and 24 prohibits forced labor, trafficking in human beings, and employment of children below the age of 14 years in factories, mines, and hazardous employment. Article 25 to 28 guarantees the freedom of conscience and the free profession, practice, propagation of religion subject to public order, morality, and health. Article 29 and 30 protects the interest of the minority by allowing them to converse their distinct language, spirit, and culture, grants them the right to establish and administer educational institution of their choice. In the event of violation of these rights, we can approach the Honorable Supreme Court of India under Article 32 of the Constitution to enforce the same. In this context, I would like to refer to a few of the landmark judgments. So, in case of Nanda Bharati versus State of Kerala, 1973, wherein it is held that basic structure doctrine of the Constitution, which holds that certain fundamental features of Constitution such as democracy, secularism, federalism, and the rule of law cannot be amended by the Parliament, and thereby the courts are safeguarding the fundamental rights. In Menaka Gandhi versus Union of India, 1978, the Supreme Court expanding the scope of fundamental rights by interpreting Article 21 and ruled that the procedure for depriving the person for their personal liberty must be fair, just, and reasonable, introducing the concept of procedural due process. And it is also held that right to go abroad is a part of the personal right. In Sunil Batra versus Delhi Administration, 1978, the issue involved was whether the fundamental rights are available to the convicts. In this regard, the court condemned the inhuman treatment and torture to the prisoners and directing that all the prisoners must be treated with dignity and respect as guaranteed under Article 21. In D.K. Basu's versus State of West Bengal, the Supreme Court considering the increasing in incidents of violence and torture in custody has laid down 7 guidelines to protect the rights of the prisoner and prevent custodial violence, emphasizing human dignity of even those incarcerated. So in Vishaka versus State of Karnataka, the Supreme Court formulated the guidelines to prevent sexual harassment in workplace, recognizing it is a violation of fundamental rights to equality, dignity, and a safe working environment. These guidelines paved the way for the sexual harassment of women at workplace Prevention, Prohibition and Redressal Act of 2013. In K.S. Puttaswamy versus Union of India, 2017, the Supreme Court declared the right to privacy as a fundamental right protected under Article 21. In Common Cause, a registered society versus Union of India, 2018, the Supreme Court recognized the right to die with dignity as a part of right to life under Article 21 and laid out guidelines for passive euthanasia. Recently, in the month of March 2026, you must have read in the newspaper the Harish Rana's case, where the Supreme Court once again, referring to Common Cause case and facts and circumstances of Rana's case, has held that artificial nutrition is a medical treatment which may be withheld in the patient's best interest and gave green signal to passive euthanasia. So this is a case, you must be aware that in year 2013, Harish Rana has fell down from the 4th floor of the building, and due to which he has sustained brain injury. And he was, in spite of best treatment also, he was not recoverable. And he was always, in his entire life, he has to depend on the medical treatment. So the Supreme Court, what it says in para number 34, keeping the condition of the patient, at para number 324, I quote, in the facts and circumstances of the case, we record a satisfaction that the twin requirement for withdrawal and withholding of medical treatment have been unequivocally met. First, it was established that clinically assisted nutrition and hydration currently being administered to the applicant constitute medical treatment. Secondly, it has been conclusively determined that the continued administration of the same is no longer in the best interest of the applicant. In the light of unanimous consensus arrived by the parents and constituted medical board respectively, we are of the opinion that the medical treatment ought not to be prolonged any further. So in this particular case also the Supreme Court has referred the permissibility of passive euthanasia under Article 21 of the Constitution at para number 46. Again I quote, our preceding analysis established that the Constitution Bench in Common Cause 2018 envisaged passive euthanasia as being synonymous with the withdrawal or withholding of medical treatment. For the Constitution Bench, these two concepts are functionally identical. Withdrawing and withholding medical treatment constitute the very essence of passive euthanasia. To comprehend the legal logic that renders such conduct permissible under Article 21 of the Constitution of India, while simultaneously holding that the active euthanasia is not permissible. It is essential to examine how the court interpreted the fundamental concept of life, dignity, privacy, and autonomy. It is through the intricate interlinking of these core constitutional values the bench established right to die with dignity and permissibility of passive euthanasia under the framework of Article 21 of the Constitution of India. Now, with the common cause and Rana's judgment, the right to die with dignity is included in human rights and Article 21 of the Constitution. Thus, it is clear that our Indian judiciary has been a strong advocate for human rights, playing a crucial role in their protection, promotion, and enforcement through constitutional remedies, expensively interpretation of fundamental rights, promotion of public interest litigation, and ensuring accountability for the violations. But there are challenges to the human rights in India because of the very system, that is the caste system, gender inequality, failure in implementation of the rules and regulations by the enforcement agencies. More particularly, the lack of awareness about the human rights among the general public and even within the state institutions. So with this, I will conclude by stating that the healthy discussions on the seminar, that is strengthening human rights, intersectionality, accountability, and inclusive rights in an evolving India would definitely make us understand the complex issues and help us to resolve the problems to a great extent. I thank you for inviting me and also hearing me patiently. Thank you.
Thank you, ma'am, for your inspiring words. I now invite Shri S.K. Vantigori, member, Karnataka State Human Rights Commission, to address the gathering.
Good morning to all. Dr. C.S. Patil, Chairman, Silpar, and President of this function. Srimati Nele Bhavani, Principal Secretary, Department of Law and Parliamentary Affairs. And Dr. Sapna is Dean, School of Law, and Professor Dr. Valamati, and all other professors, associate professors, my dear students, and the invitees. I am really glad to be part of this function. When I came here, I thought that Dr. C.S. Patil was the only guest who is known to me. But after coming over here, I came to know that Dr. Sapna, yes, is sister of my close friend Sri Sudhindra Nath, now Principal District in Bangalore. Her brother Sudhindra Nath and myself were working in Mysore. I was Principal District and Sudhindra Nath was SNC. It was very, very good friend of mine. And he is now heading the family course in Bangalore. And one more thing, Dr. Chaitra is the daughter of Sri Biranaur, who was my senior when I entered the judiciary. So, I feel that I am in the company of known persons while participating in this special occasion. First of all, I being the member of Human Rights Commission, feel to share few thoughts about the human rights. As you all know, human rights are those which a man required to lead a happy and comfortable life in the society. The basic rights and freedoms which a man requires to lead a happy life in the society are called human rights. Therefore, these rights are birthrights and inalienable rights, and no one could give these rights and no one could snatch away these rights. A man would get these rights by birth only. Therefore, these rights are recognized as basic rights of human being. And most of the human rights are later have been considered in the constitution as fundamental rights. So in this way, let me present few words as to how the concept of human rights has been evolved. The idea of human rights has evolved gradually over centuries from moral claims to legally recognized universal entitlements. During ancient medieval period, early notions of rights emerged in ancient civilizations such as India, Greece, and Rome, where ideas of justice, equality, and duty were emphasized. In India, concepts like dharma promoted ethical obligations towards individuals. Later, documents such as Magna Carta limited the powers of monarch and recognized certain rights of citizens. During 17th and 18th centuries, thinkers like John Locke argued that individuals possess natural rights such as life, liberty, and property. These ideas influenced major political transformations like the American Revolution and the French Revolution, which emphasized liberty, equality, and fraternity. During 18th and 19th centuries, several countries incorporated fundamental rights into their constitutions. Thus, there was emergence of constitutional rights. These rights mainly focused on civil and political freedoms such as freedom of speech, religion, and equality before law. The atrocities inflicted upon the citizens and the war prisoners during Second World War highlighted the need of global protection of human rights and dignity. As a result, the United Nations adopted Universal Declaration of Human Rights in 1948. This marked a turning point by recognizing human rights as universal, inalienable, and applicable to all people. Over time, the concept of human rights expanded beyond civil and political rights to include economic, social, cultural, and collective rights such as right to development, environment, education, and peace. Constitutional guarantees were recognized to promote and protect human rights. A strong constitutional framework ensures recognition of human rights such as equality, freedom, and protection against exploitation. In India, fundamental rights guaranteed under the Constitution of India form backbone of human rights protection. Independent judiciary is indispensable for promotion and protection of human rights. Courts play a vital role in enforcing rights to judicial review, public interest litigation, and interpretation of constitutional provisions. The Protection of Human Rights Act was enacted in 1993, which provides for the constitution of national and state human rights commissions. The National Human Rights Commission and State Human Rights Commissions investigate human rights violations, recommend remedies, and promote awareness. Parliament and state assemblies need to enact laws to safeguard vulnerable groups, including women, children, minorities, and marginalized communities. Role of civil society and media is also very important in promoting and protecting human rights. Non-governmental organizations and independent media help expose violations, mobilize public opinion, and advocate reforms. It is necessary to add a chapter in the educational curriculum on protection of human rights. Spreading awareness through school, universities, and a public campaign encourages citizens to respect and defend human rights. Good governance and accountability, transparency, the rule of law, anti-corruption measures, and citizen participation strengthen democratic institutions and prevent human rights violations. Institutions like United Nations Human Rights Council monitor compliance and support countries in implementing human rights standards. The concept of human rights has evolved from moral philosophy to universal legal framework, ensuring dignity, equality, and freedom for all. Their effective promotion and protection require coordinated efforts by governments, judiciary, civil society, and international organizations to build a just and inclusive society. So, in this way, the national human rights and the state human rights commissions will ensure that there should be an awareness to all the people about the human rights and take proper measures to prevent the violation of human rights, and also to register cases where there is a violation of human rights, and to submit recommendations to the government for implementation of effective human rights. Further, let me say about some practical issues which would come to our notice in day-to-day activities. Soon after I assumed charge as a member in the Human Rights Commission in the month of November 1993, myself, Dr. T. Shambat, who is the administrative member, and Chief Justice Sri L. Narayan Swamy, who is now the member of Lokpal, have thought of visiting almost all the districts to create awareness amongst the people and to sensitize the officers about the steps to be taken for preventing violation of human rights. So we started visiting the district headquarters and make surprise visits to the public institutions and ascertain as to whether the basic necessities have been provided in the public institutions, and also to receive the complaints from the public alleging the violation of human rights. Therefore, this step has created a sensitivity amongst the people to approach the human rights commissions with a grievances. Further, our visits will trigger the district administration to take proper steps in safeguarding the human rights and to protect the human rights violation cases. Further, the public institutions where we visit used to monitor the things in hostels, prisons, police stations, and public places like railway station, bus stand, and the taluk offices, where the basic needs are to be provided to the general public who approach the public offices. In one such incident, we came across a situation where a retired soldier who had put in more than 15 years service in military, after his retirement, returned to the village and applied to the revenue authorities for grant of certain 3 acres land for cultivation, as he is interested in cultivation. There is a rule in the government schemes that whenever a retired military person applies for grant of land, that piece of land shall be allotted to him for the purpose of cultivation. Though he had applied such allotment, he was not allotted any piece of land for the period of 20 years. When we visited Yagir district, he approached our commission and informed us that his application has been pending, kept pending for the last 20 years. Then we acquired the deputy commissioner, assistant commissioner, and other concerned revenue authorities as to why that application has not been attended. On records, we came to know that after 10 years, a piece of land was allotted to him, but it was not fit for cultivation. Since it is a muddy, that land contains the big stones and thorns, etc. So the purpose of granting would frustrate because the land is not fit for cultivation. Then we sat with the district authorities and see that 3 acres of cultivable land has been allotted to that soldier. Though that application was kept pending for 20 years, after our visit, within a week, that application has been disposed of and is now cultivating that 3 acres land. In another one incident in Madikeri, Virajpet, some hardy people, the tribal people were staying in the forest area where there are no any basic amenities. Then we persuaded the district administration to create road and to provide basic needs such as water facility, electricity, and other basic needs for those people. Accordingly, the district administration identified some portion of land and converted that land into a residential area and allotted the Hakupatras to those people. Therefore, why I am telling is this instances for the only purpose that when the commission started visiting the district places and other taluka places, the district administration will automatically trigger and see that all those applications pertaining to the human rights violations will be attended and the general public will be getting their redressals addressed by the district administration. So in this way, our commission is working hard to see that there should not be any human rights violation cases in the public offices. And after receiving the complaints from the public, we call for the report from the head of the department, and after scrutinizing the report, the copy of the report will be sent to the complainant for his remarks. And after receiving his comments, we scrutinize the complaint report as well as his comments. Then, if we find that there is a violation, then we will issue a show-cause notice to the concerned public officer, calling upon him to explain as to why an access would not be initiated against him. After receiving the response to the show-cause notice, we again scrutinize the entire records, and if we are not satisfied with the response given by him, then we will submit a recommendation to the government for taking necessary disciplinary action against the public officer, and also to pay compensation to the victim and to recover the compensation amount from his salary. So in this way, our commission is working hard to protect and safeguard the human rights. So I am really delighted to be part of this function, and I wish this seminar a great success, and you will all be benefited in going through the papers to be presented in the afternoon session. Thank you one and all.
Thank you, sir, for your valuable insights. I now invite Dr. Sapna S., Dean in Charge, Head of Department, School of Law, Christ Deemed to be University, to address the gathering.
A very good morning to the dignitaries on the dais, to the resource persons who have joined with us today. And all the participants who are here with us today. We have nothing but an expression of gratitude to all of you for being a part of this wonderful event that we have taken up. Speaking about human rights, there are two things that come to my mind. One was the period of 1945-1946, which was about the Nuremberg trial. Now, Nuremberg trial was an eye-opener. Now, this was the time when the war had ended and the Nuremberg trial was there in order to try the Nazi officers. What was very special and emotional about it was that while in the army they are trained to speak about respondeat superior, that means whatever my senior has said, I'm going to follow without anything to be said. Now, for the first time in the Nazi trial, in this Nuremberg trial, they said, the defense of respondeat superior is not going to apply because when war crimes are committed with so much of brutality, then it is going to be the individual accountability. Now, what did this set stage for? Two very important things. One was the UDHR in 1948 and the Genocide Convention. Now, another thing that I very importantly remember is about the Vishaka versus state of Rajasthan, which Madam also cited during the course of her talk. Now, Vishaka versus state of Rajasthan was such an important judgment to us. Now, the reason was because in 1995, when there was a workplace harassment that came up before the Supreme Court, the Supreme Court said this is a case of first instance because we did not have a law and which provision of law that we have to go by. And this is when the Supreme Court said, we are going to take the International Convention, that is the CEDA, Convention on Elimination of Discrimination Against Women, and now we're going to have the Vishaka Guidelines. And what was so trailblazing and what was landmark about this judgment was that they said, now if there is a perpetrator, it is not about individual accountability alone, but it was the institutional accountability. Now, this is the kind of the respect that they had for gender rights and for the violence that was committed against women. So these are the two things that I so much remember, and it has been such an important learning for me. And of course, not to forget the very recent how the menstrual leave was recognized as a fundamental right, and the menstrual hygiene was said it is such an important aspect about sustainability. Of course, human rights has come a long way. The crossroads that we are at, it has been challenged. And this challenge is unprecedented and it is only bound to increase. Just take a look around us and it is so easy for us to relate to this, the facial recognition in public spaces, and who can forget the Pandora's box of the Coldplay that it just opened. Now, AI-powered tools still are trained to perpetuate systemic gender bias. They are AI, but don't forget that they are trained, and that is how they're able to generate the kind of the output. So where does the input come from? The input comes from the human beings, and the human beings who still live in a patriarchal society where gender bias are so much perpetuated. Now, there was this one incident and one article that I read about, and of course, the name has been anonymized. So there is this one person, Aisha, and she has applied for a job. Now, just like the way that it happens now in the recruitments, it's the first level goes through the AI, and she was not able to get the job. Now, she had all the credentials, all the qualifications that was called for in the call for application. She takes the help of a local NGO to try to find out that why is it that she was not able to get the job. Now, the AI had marked her as low potential for two reasons. The first reason was that she was from a rural background, and of course, gender was a major issue. And the next issue was that she was from a marginalized community. And that's the reason why, when we themed our seminar, we said it is going to be gender, but we are also going to be looking at intersectionality, accountability, inclusive rights, and evolving India. So human rights or gender rights do not exist in vacuum. They don't exist by itself. There's no silos for them. They're always interlinked. They're interlinked, and that's the reason why we're speaking about intersectionality, and of course, accountability being a very important part of it. And let's also not forget the social media algorithms, which can amplify anything and everything. They just don't facilitate things, but they have the capacity, the power to amplify, to give it much more measure than you can imagine. Just think about deepfakes, think about the kind of the injustice that it is creating. The horror that it is creating is going to be huge. And of course, the digital divides, which again Chidanand Reddy Patil has so rightly pointed out, the digital divides is so huge that, so what happens in digital divides? It excludes. It creates a society which does not have equity. Those people who can have access will have access. Those who do not have access will remain without that. So this is the kind of the digital society, which is a huge violation of the human rights. And then nowadays we are speaking about predictive policing. So what happens in predictive policing? Now say for example, you're talking about something, having a mobile phone in your hand, immediately you know, lo behold, there's an advertisement which speaks about exactly the same thing that you're speaking about. Whether it's a restaurant that you're speaking about a clothing, you're speaking about a textile, you know it speaks about. So this is predictive policing. So these can happen at the level of advertisements and at the level of publications, but then it can have very huge impact. Now, what does it open to? It opens to the kind of the things, it triggers the kind of the things which are very new nowadays. So that is the reason why these are the emerging human rights. Now, say for example, right to digital identity. Again, I go back to Dr. Chidanand Reddy Patil sir, where he said the digital identity is such an important thing. So what is your right to a digital identity? Right to privacy today is going to be everything, because data is there, data is going to be fuel. So the first thing that we are speaking about is about what is your personal data, how is it protected? I mean, do you have privacy? Is the privacy also defined today? And of course, the right to the digital access. Other countries already have brought in regulations. Now, say for example, China has brought in regulations to speak about the digital humans, and so many other countries too. Now, with this, let me end this small, talk with all of you. But before that, there are a few things I will definitely have to mention. The first thing is that the inaugural address by the chief guest, Madam Bhavani, was so comprehensive. Now, it was almost like reading 100 textbooks on human rights. She explained the concept so beautifully well. It was so well peppered with the case laws, and it was just a right start to the seminar that the School of Law has taken about. And then, of course, the guest of honor, Vantigodi sir, I mean, who else could have said that from the horse's mouth, and what could be a more blessed way for us to begin with something like this? And with Chidanand Reddy Patil sir, I don't know how many of you understand this statement. It is called Undu Hoda Kondu Hoda. That means, particularly in the South Indian marriages, when you are going, we always give a written gift. Maybe it's a tambula, there's a small cover that is given. So with Chidanand Reddy Patil sir, it's always like that. You hear, but you also take away so much. He kind of makes you so uncomfortable that you carry all the thoughts with you. So this is the thing. And of course, our Revaya Odiyar is our own Revaya Odiyar, because he's our go-to person at Kilpa. So whenever we have any projects or anything, he's the person that we always go to. Dr. Valamati, Dr. Chaitra, you have done such a fabulous job, and you continue to do that. I mean, there has been so many projects that they have taken up, and so many conferences that they have led. We have only but huge appreciation. Both of them head the Gender Committee of the School of Law, and a huge appreciation to both of you, along with the band of warriors that you have under you. To all the participants, dear participants, the seminars are held not just to listen, not just to understand, but also to imbibe in you the different perspectives. All of them who have come here are experts in their field. They are practitioners in their fields. The diversity of the perspective that it gives you should trigger so many other things. And that is precisely the reason why the seminars are held. With this, I remain grateful for this wonderful event that has been organized, and thank you.
Thank you, ma'am, for your insightful words. As we conclude this session, I now invite Dr. Chaitra R.D., Associate Professor, School of Law, Christ Dean to the University, to deliver the vote of thanks.
Good morning, one and all present here. Respected dignitaries, distinguished guests, esteemed participants, and my dear students. It's my proud privilege to propose the vote of thanks on this momentous occasion of the National Seminar on Strengthening of Human Rights. At the outset, I extend my sincere gratitude to Karnataka Institute of Law and Parliamentary Reforms, KIPA, for collaborating with us in organizing this national seminar, and for their generous support and funding which made this event possible. I extend our deepest gratitude to our esteemed chief guest, Srimati Bhavani Veerabhadra Navale, ma'am, who is the Principal Secretary, Ministry of Law, Justice, Government of Karnataka, for gracing this occasion. Ma'am, your insightful address has truly enriched our understanding and inspired us to reflect deeply on the evolving dimensions of human rights. I kindly request Dr. Sapna, Dean, School of Law, to felicitate our chief guest with a token of appreciation. I I would like to express our sincere thanks to our guest of honor, Honorable Shri S.K. Vantagudi, Member, Karnataka State Human Rights Commission, for his valuable presence and thoughtful perspective on human rights. Sir, your contribution has added immense value to the deliberations. Thank you so much, sir. Our heartfelt appreciation goes to Dr. C.S. Patil, sir, Director Kilpar, for presiding over the conference. Sir, your guidance and leadership have been instrumental in making this seminar a great success. I also extend my sincere thanks to Shri Revaya Vadeyar, sir, Research Head Kilpar, for his valuable support and contribution throughout the event. I request Sapna ma'am to felicitate sir with a token of appreciation. Most important, I would like to specially thank Dr. Sapna S., Dean, School of Law, for being the conference chair and for constantly supporting, guiding, and encouraging us in organizing this event. I extend my gratitude to all the resource persons, session chairs, and participants who have contributed to the success of the seminar through their engaging discussions and scholarly inputs. I would also like to thank the organizing team, faculty members, and student volunteers whose tireless efforts ensured the smooth conduct of this seminar. Last but not the least, we thank all the attendees for their active participation and enthusiasm, which made this seminar a grand success. With this, I once again extend my sincere thanks to everyone who is present here. Thank you so much.
This session features our distinguished speakers, each presenting on a vital theme. We begin with Professor Dr. V. Sudesh, Professor, University Law College, Bangalore University. Professor Dr. V. Sudesh is a distinguished academician with over 28 years of teaching and research experience in the field of law. An alumnus of Bangalore University, he holds a PhD in labor law and has served in several key leadership roles, including officiating Vice Chancellor of Bangalore University and Dean of the Faculty of Law. His areas of expertise include labor law, intellectual property law, and jurisprudence. He has guided multiple doctoral scholars and has presented research at national and international forums across India and abroad. He has also contributed to legal policy as a member of the Karnataka State Law Commission and has published extensively in reputed journals and books. I now invite Professor Dr. V. Sudesh to share his insights on constitutional and institutional framework.
Thank you. Good morning to one and all. Professor C.S. Patil, Director Kilpar, Dr. Sapna, Dean of the Faculty of Law, Christ University, Professor Valanmati, the coordinator of this program, all the panel speakers, resource persons. I think in the morning session, you had an extensive conceptual understanding of what are human rights. I've got just 4 slides. Rest, mindful of the time and the speakers. I prepared a speech. I'll go through that. To start with, let me quote Professor Ishwara Bhatt. He writes in his book, Fundamental Rights, a study of the interrelationship. Many of the experiences about the tendencies and operations of human rights values stand beyond the barriers of time and space. They are as old as human culture. What this indicates is that human rights is not a concept which we are discussing in the modern or the post-modern era. It was there in some form or the other in the Bhagavad Gita, in many of the preachings of people from this land itself. Bhagavan Buddha, Basavanna, many others. So it's not a new concept for us to now investigate. The relevance today here is because of the modern government that we have, the kind of population that we have, the kind of rights that are being demanded by people, we have to relook at what is the constitutional and institutional framework for protecting human rights. Remove the slide. Next. Yeah, this is, though my topic is on constitutional framework and institutional framework, just to set the trend that much before the United Nations, the UN Declaration of Human Rights, I give credit to the International Labour Organization, which was formed just at the end of the First World War, in recognizing one important human right, considering the laborers. And this declaration marks the beginning of the modern trend of institutionalizing protection of human rights. By adopting the Forced Labor Convention 1930, the International Labour Organization, through this convention, eliminated forced or compulsory labor, forcing signatories to ban, penalize, and enforce the law against it. And later, of course, you have the UDHR, which is a milestone document in the history of human rights. The declaration was proclaimed in 1948, and now it is widely recognized, inspiring several constitutions, including India. I just quoted this, friends, to set the trend for what is the framework that we have. As all of us know, human rights are those basic rights which belong to every human being simply because he or she is a human person. They include the right to life, liberty, equality, dignity, education, freedom of speech, freedom from discrimination, and protection against exploitation. Even when this was drafted, credit must go to an Indian, a member of the Constituent Assembly, and also a delegate to the United Nations Human Rights Commission, Hanslal Mehta, if you remember. Hanslal Jeev Mehta, who drew attention towards the terminology being used in the UN Declaration. She played a significant role ensuring that Article 1 of the UDHR was made inclusive and is credited to changing the phrase from all men are born free and equal to all human beings are born free and equal. This indicates that the human rights document, the terminology itself was a little shaky at the initial stage, and now we see that so much of literature are now being written on how gender parity must be there in the protection of human rights. After a long period of subjugation and suppression of the human rights, India, after independence, chose to become not only merely a political democracy, but also a social democracy. The framers of our constitution understood that freedom has no meaning unless it protects the dignity of every individual. Therefore, the Constitution of India is often described as a human rights document, the first framework of independent India, the Constitution of India 1950. The constitutional framework for the protection of human rights in India begins with the preamble. The preamble itself espouses the protection of human rights. The preamble promises justice, which is social, which is economic, which is political, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and fraternity, assuring the dignity of the individual. These ideals form the foundation of all human rights in India. So if we are tracing anything, we trace human rights protection framework from the preamble. And the most important constitutional protection is found in Part 3 of the Constitution, which contains the fundamental rights. These rights are enforceable in courts and are available against the arbitrary actions of the state. First, Article 14 guarantees equality before law and equal protection of laws. It means that no person is above the law and everyone must be treated equally. This article has become the basis for challenging arbitrary and discriminatory actions. All of you are aware, in the famous case of E.P. Royappa versus State of Tamil Nadu, the Supreme Court held that arbitrariness is the very opposite of equality. Therefore, any arbitrary action by the government violates Article 14. Similarly, in Maneka Gandhi versus Union of India, the court gave a very broad interpretation to human rights. The government had impounded Maneka Gandhi's passport without giving her a fair hearing. The Supreme Court held that any law affecting life or liberty must be fair, just, and reasonable. It connected Article 14, 19, and 21 together and declared that human rights cannot be restricted through arbitrary proceedings. Article 15 prohibits discrimination on the grounds of religion, race, caste, sex, or place of birth. Article 16 guarantees equality of opportunity in public employment. In the very famous case of National Legal Service Authority of the Union of India, commonly known as Nalsa case, the Supreme Court recognized the right of transgender persons as third gender and held that they are entitled to equality and dignity under Articles 14, 15, and 21. And recently, the law is amended. There is a controversy over that the right to choose the sex has been now restricted. It's a big issue now. Probably once the amendment is gazetted, a lot of us will have to say a lot of things on that. Why there is a restriction on choosing of the gender there. Anyhow, this judgment was a major step in the protection of human rights of the transgender community. Article 17 abolishes untouchability. It is one of the strongest provisions in the Constitution because it attacks social injustice directly. With all the experiences of Baba Sahib Dr. Ambedkar, this article still plays a very important role. The practice of untouchability is not only unconstitutional but also punishable by law. Next, Article 19 guarantees important freedoms such as freedom of speech, expression, movement, peaceful assembly, freedom to practice any profession. These rights are essential in a democratic society because without freedom, human rights lose their meaning. In Shreya Singhal, very famous case, all of you are aware of it. Shreya Singhal was the Union of India. The Supreme Court struck down Section 66A of the Information Technology Act because it violated freedom of speech and expression. Unaware of this, many people are still prosecuted, which was of course brought to notice to the Supreme Court very recently. The court held that vague restrictions on speech are unconstitutional. And now, coming to Article 21. The heart of the human rights framework in India is Article 21, which states that no person shall be deprived of life or personal liberty except according to procedure established by law. Initially, Article 21 was interpreted narrowly, but over time, the Supreme Court expanded its meaning and included within it many human rights necessary for living with dignity. In the famous case of Francis Moraes versus Administrative Union Territory of Delhi, the court held that the right to life does not mean a mere animal existence. It includes the right to live with human dignity. May I remind you of another case where the protesters sleeping on the Ramlila Maidan in Delhi, after about months of passment in the court, the police commissioner passed out, they must be vacated, and these police people come in the midnight, lathi charge and make people run away. In that case also, the court said, okay, they may be sleeping beyond the permitted time or the time allotted for them to protest, but this is not the way you chase them. An earlier case in this regard, Olga Tellis versus Bombay Municipal Corporation. The Supreme Court held that the right to livelihood is part of the right to life because a person cannot live without means of livelihood. Law students will know that it happens in all cities, corporations. Bombay Corporation, where migrant workers who came to work there, slept on the pavements in the night. And suddenly, municipal corporate decided they must be vacated. This question arose that you cannot imagine the life without means of livelihood. In Husainara Khatun, one another famous case, state of Bihar, the court recognized the right to speedy trial as a fundamental right. Thousands of under trial prisoners who had spent years in jail without trial were released because of this judgment. In Sunil Batra versus Delhi administration, D.K. Basu versus State of Bengal, the court protected prisoners and arrested persons from torture and custodial violence. And today, if you open the newspaper, or yesterday, the decision was given, you must hate these kind of judgments. Life sentence to, I think, 9 of the policemen. This makes us believe that human rights framework is alive in India. People are speaking, people say, what a wonderful judgment. And the judge writes, I just read the 2-3 lines there. He said, death sentence is the best sentence because life imprisonment will not deter others. We must hate, many people will come out writing on the judgment, students read that and understand the sentiments of the judgment. Similarly, in Vishaka versus State of Rajasthan, the Supreme Court treated sexual harassment at the workplace as a violation of human dignity and equality. And consider this framework many years ago, when the law was not there, Supreme Court does this. The court laid down the Vishaka guidelines to protect women at workplaces until Parliament enacted them later on. Justice K.S. Puttaswamy versus Union of India, the Supreme Court recognized the right to privacy as a fundamental right under Article 21. In today's digital age, where personal information can easily be misused, this judgment is extremely important. Another important aspect of the constitutional framework is the directive principles of state policy in Part 4 of the Constitution. Though these principles are not enforceable in courts, they guide the government in making laws and policies for social and economic justice. So social and economic justice is also part of the process to protect human rights. For example, Article 39 directs the state to ensure equal livelihood and prevent concentration of wealth. Article 41 provides for the right to work, education, public assistance. Article 42 speaks about the humane working conditions, maternity relief. Article 45 provides for free and compulsory education for children, etc. Now, these are the principles which have inspired several welfare laws and judicial decisions also. The right to education became a human right through the 86th Constitutional Amendment, which inserted Article 21A. This article guarantees free and compulsory education to all children between the age of 6 and 14 years. Unni Krishnan versus State of Andhra Pradesh, the Supreme Court held that the right to education is part of the right to life under Article 21. This judgment paved the way for Article 21A and the Right to Education Act. Apart from the constitutional framework, India has created several institutions for the protection of human rights. The most important institution is the National Human Rights Commission, established in 1993 under the Protection of Human Rights Act 1993. The NHRC investigates complaints of human rights violations, visits prisons, recommends compensation, conducts research, and spreads awareness about human rights. It can take action in cases involving custodial deaths, police atrocities, bonded labor, child labor, violence against women, and other abuses. The NHRC is assisted by the State Human Rights Commission in different states. Besides the NHRC and the SHRC, there are many other institutions. I'll name a few. The National Commission for Women, which protects the rights of women. The National Commission for Scheduled Caste. The National Commission for Scheduled Tribes. National Commission for Minorities. National Commission for Protection of Child Rights. National Commission for Backward Classes. These institutions ensure that the rights of vulnerable sections of society are protected. The judiciary itself as an institution is perhaps the strongest institution for the protection of human rights in India. Through the power of judicial review, courts can strike down laws that violate fundamental rights. Under Article 32, a person can directly approach the Supreme Court for the enforcement of fundamental rights. In fact, Dr. B.R. Ambedkar called Article 32 as the heart and soul of the Constitution. Similarly, Article 2 to 6 and the various writs that are issued under Article 2 to 6. Public interest litigation in India has made human rights accessible. Through PIL, even a person who is not directly affected can approach the court for the protection of the rights of the poor and disadvantaged people. For example, in Bandhuva Mukti Morcha versus Union of India, the Supreme Court took steps to free bonded laborers. In MC Mehta case, the Supreme Court linked environmental protection with the right to life and held that every person has the right to clean environment. However, despite such a strong constitutional and institutional framework, many challenges remain. Human rights violations continue in the form of custodial torture, discrimination, violence against women, caste oppressions, child labor, communal violence, and misuse of technology. Many institutions also suffer from lack of resources and limited powers. The recommendations of the NHRC are often not binding. Therefore, there is a need to strengthen these institutions, create greater awareness, and ensure effective implementation of laws. To conclude, India possesses one of the most comprehensive human rights frameworks in the world. The Constitution provides the vision, the courts provide protection, and the institutions like the NHRC provide support. Landmark judgments of the Supreme Court have transformed human rights from mere words into living realities. But the true success of human rights depends not only on laws and codes, but also on the attitude of the society. Every citizen must respect the dignity, equality, and the freedom of others. As Dr. B.R. Ambedkar wisely said, rights are protected not by law alone, but by the social and the moral conscience of our society. My last slide, please. Gentlemen. Let us therefore strive to build an India where every individual can live with dignity, equality, and freedom. Let us protect each other. Let us dine together. Let us do illustrious deeds together. Whole mankind is one, is one's family. Friends, keeping in view the time limit, I've just taken you very summarily. Most of your law students, you understand. Thanks for giving it to Valarmati for giving the first session, because I think I set the trend now. Other speakers can pick up. I have not touched anyone's. I saw the list very carefully. I was very careful that I must not tread upon others' domain. Thank you so much for this wonderful opportunity. Thank you.
Thank you, sir, for your valuable insights. Now, I invite Dr. C.S. Patil, President of Kilpar, to present a memento as a token of our gratitude.
Happy to receive from the doyen of legal education. And I want a very good photograph of it. Thank you, sir.
Next, we have Dr. Akhila Basanandi. Dr. Akhila is currently an Assistant Professor of Law at the National Law School of India University, Bengaluru, India. She was a visiting fellow at Sydney Sussex College and the Department of Politics and International Studies, University of Cambridge. She has obtained her doctoral degree from the Center for International Legal Studies, Jawaharlal Nehru University, New Delhi. Her doctoral thesis examines the implementation of international law in the Indian legal system, identifying the patterns of convergence and integration between them. Her research interests include the interface between international law and domestic law, engagements of the judiciary with international law, third world approaches to international law, studies in water law, and feminist studies. She has co-edited a book on water laws and authored articles on water resource management and law. She has also published articles on Vachanas and the feminist movement, international rule of law, domestic courts and international law, third world approaches and feminist approaches to international law. She has previously taught at Maharashtra National Law University, Mumbai, Christ University, Bangalore, Karnataka State Law University, Hubballi, and CMR University, Bangalore. She has also delivered a series of lectures at the Institute of Military Law, New Delhi, to the officers attending judge advocate courses. I now invite Dr. Akhila Basanandi to deliver her address on international and comparative perspectives of human rights.
Respected dignitaries, fellow colleagues, and my dear students, a very good morning to one and all. Let me begin by congratulating Kilpar and School of Law, Christ University, for organizing a national seminar on a subject that is timely and relevant. So the very theme, strengthening human rights, intersectionality, accountability, and inclusive rights in evolving India, like I said, is both timely and relevant, particularly in the context of how intersectionality plays a very important role in the today's context. So I am again grateful for being invited to speak on international and comparative perspectives. But what I would tend to focus today is not to delve anywhere into the comparative perspectives. That requires me to look into a lot more of jurisdictions, but I'm very happy to have that conversation separately. But what I do today is to discuss a bit on how India is engaging with international human rights instruments, and maybe touch upon a bit on the area of universal periodic review, given the fact that within this year or early next year, we are going through that cycle of universal periodic review process. So as I said, the term intersectionality is something that touches very deeply to my heart. And I tried to see if I could focus the entire talk on the intersectionality aspect, but I was quite surprised at the fact that I couldn't even find one instrument in international human rights regime that even touches upon the idea of intersectionality. So the way Kimberly Shaw talks about intersectionality is how there can be layers of discrimination simply depending on the kind of identities that you have. So there could be discrimination that would manifest because of your gender, it could be because of the caste, it could be because of the place that you hail from, or your gender. It could be varied areas that could add upon the layers of discrimination simply because of the multiple identities. Then I tried to see if there's something that I can find within Indian jurisprudence, and then I was quite happy that there's one 2021 decision by Indian Supreme Court, that is Patan Jamal Wali versus Union of India, which is one of the only decisions that I think I found that uses the term that how certain people are susceptible to intersectional discrimination, and here it happens to be a Dalit woman who was blind. So there is gender, there is disability, and there is caste discrimination. There have been multiple instances that Supreme Court might have gone into looking at the intersectionality lens, and for somebody who has researched on this area for 13 years and how proudly we speak about Vishaka appears to be a fantastic judgment on sexual harassment at workplace, but the intersectionality of caste is something that I found was missing in that judgment. So I come with that kind of critical angle as well. The point I was trying to make is, unfortunately, international human rights regime, though touches upon some aspects. For instance, if you pick up CEDAW, and if you look at CEDAW, there could be certain provisions that you can find on rural women, but were the drafters really mindful of that intersectionality? The answer is unfortunately no, right? So we don't see that as much happening in international legal area, but nevertheless, the tendency of many of us has been such that we try and look forcibly into international laws to find some kind of solace. And we also have found that Indian judiciary relying very, very heavily on international instruments. So what we will do today is perhaps focus on the 9 core human rights instruments. And one of you can simply ask me, why are you calling just 9 instruments as core human rights instruments? I know we can approach that argument with a kind of critical angle, but what the Office of High Human Rights Commission has done that is that it has looked at 9 aspects of human rights, or 9 instruments of human rights that can be called as core because of the kind of global consensus that they have received, and they are conceptually grounded on the International Bill of Human Rights. So we are aware that we have UDHR, we have ICCPR, ICSCR, the 2 covenants, and our declaration. So the 9 core human rights instruments that we identify as the core in international human rights regime basically derive their content from these 3 instruments, right? And there's a huge number of membership. There are many signatories to these 2 core human rights instruments. Another feature of these core human rights instruments is that each one of them establishes a treaty body. And when each one of them establishes a treaty body, there is some kind of power that the countries give to these treaty bodies. And these treaty bodies make general comments. For instance, how do you perhaps define gender, which CEDAW has not done. And then you look at the general comment given by the committee on CEDAW to see how do you define gender really. So they provide certain kind of general comments to add to the interpretation to the existing norms in each of these human rights instruments. And these treaty bodies also sometimes have an individual capacity to entertain complaints. And this is one of the reasons why India has not signed to any optional protocol that establishes these treaty bodies, that you don't want the treaty bodies to have that kind of sovereignty to accept the complaints against your state. But that's some kind of power that the committees also have. So 9 core human rights instruments: the Convention on Racial Discrimination, the Covenant on Civil Political Rights, the Covenant on Social, Economic, Cultural Rights, the Women Convention, Child Rights Convention, Convention on persons having disabilities, Convention on Torture, Convention on Enforced Disappearances, and Convention on Protection of Migrants and their families. So these are the broad 9 core conventions that we have in the present context. Now, I thought it would be interesting because to discuss some kind of challenges that we face, particularly to these 9 core human rights instruments. One of the challenges that we see is that India has been very active with regard to its signature and ratification to the 7 human rights instruments or 6 human rights instruments. It has signed but not ratified 2. It has not signed nor ratified the 1. So the ones that it has signed and not ratified are the Convention Against Torture and Convention on Enforced Disappearances. That's quite intrigued by the fact as to why has India signed but not ratified. And the convention it has neither signed nor ratified is a convention on the protection of workers, migrant workers and their families. Now, I'm not going to delve into that area of the conventions or treaties that India has signed and ratified because there was a brilliant lecture and couple of sessions this morning where we saw a series of Supreme Court decisions which have incorporated a few instruments, tried and articulated our Article 21 in a direction that it encompasses different kinds of rights that we perhaps didn't think of before the revolutionary Maneka Gandhi decision. So I'm not going to enter into those areas. My focus is on the reasons why India does not want to ratify the Convention Against Torture and Conventions on Enforced Disappearances. Now, Convention Against Torture, India has signed, and I'm sure that students of PIL, Public International Law, would understand the difference between signature and ratification. When you are a dualist state, signature simply means that you are in principle aligned to broader idea of the convention, but there's also some kind of promise that you'll go take this convention back to your domestic legal system where there's going to be a ratification to it. In other words, for that convention to literally translate into a set of rights on a few on your citizens, you need that kind of requirement of ratification, right? So this is what was quite surprising because Convention Against Torture, we are all aware that there have been plenty of decisions by Indian Supreme Court. D.K. Basu decision is one fantastic decision where we have the set of guidelines as to how there has to be rights for the arrested, detainees, the prohibition against torture. We are aware of all that. When India in principle wants to align with this idea against torture, what is the reason that it does not want to ratify the convention is the question that I intended to engage with. And the rhetoric of state sovereignty is something that I meet often when I ask such questions. That India does not want to lose its sovereignty. And this argument is particularly in the context of AFSPA rule that we have, the kind of special forces which are there in certain regions. The minute you enter into or ratify CAT, that's the Convention Against Torture, there is a need that you will bring a domestic legislation, and there perhaps it might not stand the test of Article 14 if you were to leave a few areas outside the purview of that domestic legislation, right? So in order to protect or in order to continue the function of AFSPA and those powers in these certain regions, India does not want to have a domestic legislation. The other reason that I stumbled upon is with regard to the definition of torture. If one were to look at the definition of torture as by CAT, it also includes the mental torture. It includes the mental agony. Now, I'm not aware of any incident where the investigation has happened that the person has said that I have absolutely not suffered mental agony. So that itself presents the problem that there is some kind of loophole where we are not intending to add that mental torture as a part of torture. So that's one conceptual problem. Third is that there are some kind of procedural immunity. The former CRPC article section 197 and the current BNSS section 218 has some kind of power of sanction that needs to be obtained before prosecuting the public servant. But now the BNSS has relaxed a bit, wherein if the government does not respond in 120 days, then you may go ahead and have a prosecution against the public servant. But still, we somewhere engage with that immunity concept, which is why we just don't want to throw away the kind of power that we have. And then it was quite intriguing to see that there is 2019 decision. And the case is Ashwini Kumar versus Union of India. This was a case by the former law minister. I remember reading that the Supreme Court said it is not my task to advise the legislature to bring a transformation or to ratify the Convention Against Torture. But what I can best do is that tell you that there are a couple of provisions in the Convention Against Torture that have gained the status of customary international law. For instance, we have Article 3. So even if India says, I'm not going to ratify the convention, you are bound by Article 3 because it has gained the status of customary international law, right? So that is something that I saw was positive, where there is some kind of reluctance, but then you can have a bit of engagement through that other discipline of international area. There have been attempts legislatively as well. I can think of 2010 and attempt to have a bill which is a prevention of torture bill, but we don't see that come through. In 4 years, as the government changed, the bill was just dropped. But NHRC has been quite vocal in trying to argue that we need to have a domestic law that is a standalone law on the prevention and prohibition of torture. Law Commission report is also worth a mention. The Law Commission report of 273 of 2017 also provides a draft bill on the prohibition of torture along with its report. But what I found interesting is that we are not essentially walking in the direction, or the primary reason for drafting this bill is not having a kind of moral obligation against torture, but it more or less is the difficulty that is faced to extradite criminals in the absence of anti-torture law. You could just pick up the Law Commission report and read one of the preliminary reasons that they say why they are going ahead with this kind of attempt in wanting a legislation is because there is such a difficulty in extraditing criminals from other jurisdictions because we don't have a anti-torture bill as such, right? So these have been a couple of legislative attempts, but nevertheless, the decision that came yesterday is something that we can applaud for the kind of position it has taken against torture. But internationally, are we aligned? My answer is unfortunately no. The next convention that I have in mind is the protection of persons from enforced disappearances. So India has again signed this, which in other words mean that we don't have a problem in principle. But what does this mean is that, what does the term enforced disappearances mean is that when a person is arrested or detained or abducted by a state or government, and it's followed by a refusal to acknowledge such an action. So you don't have officially any information about such person just being absconded, right? So again, what are the problems? I started to look at it and I found a similar reason of AFSPA as well as the immunity that is granted under BNSS. What an interesting area is that I found that there was some kind of reasoning that was given saying that India has a better protective regime, and a better protective regime was pointed towards the constitutional writs, for instance, our habeas corpus, and the kind of developed protective regime both in BNS and BNSS on kidnapping, abduction, wrongful constraint, murder, etc. But does that again absolve us of that requirement of arguing for a standalone legislation? The answer is no. The third reason could be on the aspect of non-refoulement. Students who are acquainted with international refugee law or areas of asylum would agree with me that one of the basic principles or one of the basic protective rights of a person who is a foreigner or an alien is their right of non-refoulement, which means that a person cannot be deported back to the place from which a person is fearing persecution. You can't be sent back to the place from which you have fled, basically, because you fear a threat. Now, India has not signed the Refugee Convention. India's position on non-refoulement has been very inconsistent. Until the Salimullah decision, we were very happy reading that principle along with Article 21. But the Salimullah decision, we said that we are not a party to Refugee Convention, absolutely ignoring the fact that principle of non-refoulement itself has gained again the status of customary international law, not requiring a specific ratification or signature of such instrument. So India intends to have that power, and through the Foreigners Act, we have seen that the central government has the absolute power to expel, to send back any person that the government feels is not for the interest of the country. The reasons could be varied, and one of the very interesting reasons is national security. And I come with a pinch of critique when I say national security, because I find the term national security very porous. We can read many aspects to national security, so I am of the opinion that non-refoulement simply can't be on the aspect of national security. And then there is some kind of reluctance also, because when international law functions, we see it's not mostly consistent. We have seen that international law function very selectively, right? There are instances that it takes into cognizance, there are instances that it does not take into cognizance. I don't have to speak about the current human rights violations, and it does not sound morally right to stand before you, particularly when there have been such grave human violations across the globe. So international law is very selective on that. Now what India, and I think India is fair to believe that the minute there is a situation of enforced disappearances, there is a lot of culpability that the international community would presume on the state. And I think that's fair because of that kind of unpredictability of the way international legal order functions. They are quite strict, and they subject a lot of jurisdictions into greater scrutiny as compared to the Western nations, where most of them simply glide by without having any kind of accountability to the international legal order. So having said that about also Dr. Chaitra, remind me when I'm closer, around 5 minutes. I am? Okay. So the last instrument that I have is on migrant workers. Migrant workers, I would just simply comment on two aspects. One, of course, is that there's a paradoxical dilemma that India faces, because it's both labor sending and labor receiving country. So they want the better protection for the labors that they send, but not really the labors that we receive. And also the kind of convention, if you were to quickly go by the convention, you see that there is a great protection that is given, and it does not make that distinction between the migrants. There is no set of protection for legal, set of protection for illegal migrants. So that distinction is not something that the international law maintains, which is why India wants to have that control and say over the illegal migrants and their rights. Plus, the convention, if you go through it, particularly Article 27 onwards, there are many welfare measures such as social security, medical care, public education. So we are a little reluctant to see if that can be extended to the whole lot of migrants that we receive. And then there is a rhetoric of national security, because our borders are porous and we know from where there is an influx of people. So in at least this migrant aspects, we see that India has been very vocal towards having a bilateral arrangement where it is based on the idea of reciprocity. You extend these benefits and the migrants from your place would be extended these rights and benefits. So that's about it. And I'll just take 2 minutes to, okay, thank you so much. I'll just take some couple of minutes to talk about UPR, and I'll just do this quickly. UPR is a cycle that happens in every 4.5 years, where the United Nations Human Rights Council does a review of all state jurisdictions and their functioning with the human rights treaty bodies, their protection of human rights, how they have ratified, how they have implemented, have they done well with the human rights as such. So this is a peer review process. So the reports essentially are on the actions that are taken, and there are certain recommendations that would be given by a few state parties. So this is about the 4 phases. I'll quickly go through the 4 phases. The first phase is when state that is subject under the reviews produces a national report, and in that national report it explains what it has done in the past 4.5 years. And I suggest, I have a copy, but because of the paucity of time, I'm not going to go through that. It is discussed under the broad heads of civil, political rights, economic, social rights, and other cross-cutting areas like business and human rights, environment and human rights, and lot many aspects such as these. And there is another report that is submitted by the United Nations treaty bodies as to how that state has taken the recommendation, has it filed an yearly report with them. So that recommendation is another document that comes from the side of United Nations. And third, there is a stakeholder report that is also supported, which is essentially a kind of document that the non-governmental organizations and the civil society groups produce. So the 3 documents happen at the preliminary stage. So these 3 documents are basically reviewed. There are a couple of questions which would be asked, and then there is a process of assessment, and there are 3 countries. So Troika is basically appointed. There are often 3 countries. The cycle that India recently ended was in 2022. Nepal, Netherlands, and Sudan were those 3 countries which made that assessment as a rapporteur, and they prepared a set of recommendations, and finally there is an implementation. So broadly looking, India has been commended for the kind of work it has done, particularly in the context of substantive equality through the Naute Johar judgment, the kind of amendments that have brought to Atrocity Act, the kind of effort towards the transgender rights. But then there are a couple of questions that have been raised, and I'll stop with these questions. That one of the very important questions which have been raised more than 40 nations at least is that why again is India reluctant to sign our Convention Against Torture, enforce disappearances? What about the National Human Rights Commission, its functioning? Because if you look at our score in terms of the GANHRI, which basically makes an assessment of how human rights institutions work, this decision has been deferred. So the questions are being raised as to why the national human rights institutions have not been functioning well. The next question is on the context of how certain rights of minorities have been not protected. What is our position on capital punishment? These are broadly the set of questions I can think about. And of course, the Supreme Court decision recently, which came about a year and a half ago, on the rights of the homosexual couples, if that can be called as a situation of marriage. These are the questions which have been raised as to why is India so much reluctant to walk in that direction? Why isn't there a progressive way through? But I would want to conclude saying that when I looked at Indian jurisprudence, let me assure you that India is doing quite well. Because I think India, along with South Africa, are 2 jurisdictions which have been cited across by many authors as those jurisdictions where the rights are realized, let alone the civil and political rights, but the rights such as social, economic, and cultural rights have been progressively realized. And we can take that appreciation and not really worry so much about the optional protocols, which we are not in a position to sign, because my understanding of the research on international human rights regime is that we can't emphasize so much on universality. There is always a cultural relativist critique, and international human rights regime operates very, very selectively. So I think there is a need for strengthening domestic legal enforcements and making the progress there than having to worry about the set of reports that have come about. Thank you so much for patiently listening to me, and thank you Professor Valarmati and Professor Chaitra for this opportunity. Thank you.
Thank you, ma'am, for your valuable insights. Now, I invite Dr. C.S. Patil, Director of Kilpar, to present a memento as a token of our gratitude. Now we call upon Dr. Priya Varadarajan, Dr. Priya Varadarajan is the founder and chief executive officer of Durga India, a pioneering organization working to transform public spaces and systems to be safer and more inclusive for women and girls. With over 2 decades of experience spanning philanthropy, public policy, and grassroots engagement, she has led innovative large-scale interventions addressing gender-based violence through community mobilization, behavioral change, and institutional partnerships. Prior to founding Durga India, she held key leadership roles at the Azim Premji Foundation and Co Impact, where she advanced initiatives on gender justice, disability, and mental health. Under her leadership, Durga India has introduced path-breaking programs, including safety innovations in public transport and bystander intervention training across education institutions. A respected voice in policy and practice, Dr. Varadarajan continues to contribute to state-level reforms and academic spaces, making her work central to contemporary efforts toward gender equity and systemic social change in India. I now invite Dr. Priya Varadarajan to speak on human rights and vulnerable communities.
Good morning, everyone. My special greetings to all of you, and it's been a very long morning, I realize. I will try to make it as simple and as much as it's connected and centered with people as possible. Thank you so much to all of the dignitaries, the speakers, presenters, and especially to Kilpak and the Christ University for having me here. Patil sir, your talk was humorous, but it felt very real, and I've personally learned a lot that no matter what, reading a book will definitely help. Before I start, I think it's impossible not to talk about the really difficult and I think very, very surreal times that we are living in, right? I wake up sometimes thinking that I hope it was a nightmare where I saw thousands of children, women, and others being killed, blown apart, all in the name of human rights. It's literally raining fire. My name is Priya, and I run Durga, and we work on gender-based violence in public spaces. My first disclaimer is, as an organization, we are an anti-carceral organization and believe that justice to the survivor is restorative and it comes from community allyship and bystander action. And secondly, I'm not a lawyer, I'm not a doctorate, I am a social worker. Rights of vulnerable and marginalized groups, from recognition to responsibility. This is the topic that was given to me. So amid lawyers and seniors and everyone who understands the law, I'm actually a little scared. But I would like to focus only on the rights of vulnerable people as a result of law and policy. Our constitution, with all the articles and the BNSS, provide for one of the most comprehensive provisions and laws for rights for everyone, including the most marginalized, and we've been hearing this repeatedly from this morning. We may in fact claim to have some of the most sophisticated laws for people, many necessary and some totally unnecessary, like the one we saw last week around the Rights to Transgender Persons Act. We spoke so much about Vishakha guidelines, both Shilpa madam spoke about it, Suresh sir spoke about it, Bhavani ma'am spoke about it, but Bhavri Devi, right, I want to talk about her. When I met her, we've all in some sense profited out of her story, out of her most inappropriate, violating experience, but she didn't have money to even recharge her phone. Such is life. People make profits out of vulnerability and do nothing when it comes to protecting the rights of the same community they profited from. So most recently, examples I would like to quote are people like Vijay Sethupathi, Ayushmann Khurrana, who've profited tremendously making movies out of people who are coming from across the gender spectrum, but yet chose to say nothing when the bill gets passed in both houses and then eventually becomes an act. So my real question is, what is made of the laws and policies when people continue to get more vulnerable? Rights definitely come with accountability. As a social worker, I will take the life of one vulnerable community that I work with and take one aspect of their right, which is safety. Suresh sir very correctly spoke about the ILO, and so did Akhila ma'am when she spoke about the labor rights. So I'm taking the life of a Paura Karnika in Bangalore, and she picks up dry waste from all of our residences. Now, when we think about the hegemony of her vulnerabilities, then she's a migrant worker. She's oppressed by caste because most of them come from Dalit backgrounds. Most of them are women within GBA, so as a woman, she's marginalized, of course. And then, of course, her job brings vulnerabilities around her health. She's definitely not educated. In fact, she's struggling and doing her everyday work so that her children can be the first to get to school. Majority of them are single income earners, and therefore domestic violence, alcohol abuse, intimate partner violence, sexual harassment in public spaces, sexual harassment at workspaces because they always report to men who are supervisors, and harassment from everyone. In fact, someone was telling me, one of them was telling me that she's lost her name. People who ask her to pick up the kachada from her house actually call her kachada, right? So she lives on a double-edged sword on fire. So on the safety front, if we look at her life, right, she actually should be covered by various laws, and I may just be picking up a few. All of you know the laws. So there's the Domestic Violence Act, there's the POSH Act that we've been referring to multiple times. There's laws that we have which is to prevent outraging the modesty of a woman, and then there are laws around preventing atrocities against Dalit people in our very state. But is she really safe? And what is human rights if safety is not centered? So when she, for instance, takes a complaint of domestic violence, her case is not heard because in a patriarchal system that we thrive in, she's usually made literally in front of us to shake hands with her partner and go back home saying that, can you not just cook better, or can you not just continue to wear your toe ring to keep your family at peace? And if a woman takes her personal story to the police station or to the court, and if she's not given justice, she will not be able to go back home because she's already living with the violator. If she complains about sexual harassment in a public space, she's almost laughed at to say, who's going to sexually harass you? Have you seen your face? And none of what I'm saying is made up. These are real everyday battles that we work on or fight on. So she has no way to go to sexual harassment in public spaces. Sexual harassment in the workspace. Now what's that mean? Because she's always reporting to men, right? And so sexual harassment at the workspace is a given. They think if I have to step out and work, I need to accept this. There is no IC in their workspaces. And LC, I don't know if any of us has seen it, right? So what is it when we're talking about human rights and vulnerability when it doesn't reach the most vulnerable? So what is vulnerability? Or who is made vulnerable? What makes people vulnerable? So we feel that people are made vulnerable by the same systems that are made to protect their rights, right? It is with this power that the system carries that allows it to be exclusionary and therefore be unequal. At this stage, it is also important to see who owns these rights. It is people with power, it is wealthy capitalists, and it is cis-het men, from what we saw last week. Marginalization, therefore, is shaped by systems like caste, gender, class, religion, disability, sexuality, occupation, age, geography. I can go on and you will not get lunch. These systems decide who is heard, who is believed, who is to be protected, and who can be ignored. So going back to my Paura Karnika, will she be seen, heard, provided for at all? I don't think so. So we often think of rights as something that's to be written in the constitution, something legal, something distant, but it's actually very, very simple. We feel in the area of social work that what is human rights is just being treated with dignity, feeling safe in your body and your surroundings, having a voice, being able to move, work, and exist without fear that Patil sir also spoke about, and then knowing that you will be heard. So, who actually gets to experience these rights in our everyday lives, right? We're now thinking about women in public spaces. Do we experience this in our everyday lives? And I don't see a very vociferous nod. I think no, most of the times. What about people who are marginalized by caste? They don't see their rights on an everyday basis. What about people marginalized by religious reasons? No, definitely not. Informal workers, of course, lack these protections. And gender diverse, non binary people, soon we will say they don't exist. Infrastructure and policy limitations also deny the rights of persons with disabilities. So, human rights are for some people who will never have to experience any of this. So when we come to the Trans Persons Rights Act of last week, I'm not here to talk about why it's not working, but I'm here to say that this is one classic example of where laws sometimes are made in the same way it got made last week. No one was asked. The community that gets affected is not represented. Dignity is stripped. Decisions are made randomly by people who are not best placed. What will this lead to? All of us feeling unsafe eventually. So these systems essentially decide who is heard, who is believed, who is protected, and who can afford to be ignored. Therefore, who is actually getting heard and protected? My answer to it is power. There is a saying that power corrupts and absolute power corrupts absolutely. And that power need not stay in institutions that work for us. It stays within each of us. It gives us the choice to look away. So I want to talk a little bit about the role of silence and the power that we all carry. Violence and discrimination do not continue only because of the perpetrators. They continue because of silence, because of our normalization, and because of people like us choosing not to act. We have all seen moments when something felt wrong and we told ourselves, this is not my problem. But the truth is, silence is not neutral. It supports the status quo. For example, speaking up in any manner right now against the Trans Persons Act is important as our role to show solidarity and support and not remain silent. How do we ensure dignity for people in everyday life? It comes from people who choose to act differently. Because allyship is not about feeling bad alone or agreeing with people in principle. It is about what you do in real situations. So therefore, in conclusion, what I'm here to say is we know we do not lack laws. What we lack is the everyday translation of these rights into lived realities. Rights are not just legal guarantees, they are social practices. If vulnerability is created by social systems, then responsibility lies with all of us to challenge and change these systems in our daily life. Policies and interventions must be designed with consultation. If not, I think even better would be by the communities themselves. It is not a matter to include, I think it is our right to be part of decision making. Legal protection should be accessible, easy to understand, and the process should be simple for everyone to follow and get justice. So what do? Challenge and question discrimination in daily life, speak up, intervene, actively oppose exploitation or harassment, become an ally, and refuse to normalize any form of harassment. Therefore, instead of saying who is vulnerable, maybe we should ask what systems are making people vulnerable and how am I part of changing or maintaining those systems? Thank you so much for patiently listening to me.
Thank you, ma'am, for your valuable insights. I now invite Dr. C.S. Patil, Director of Kilpar, to present a memento as a token of our gratitude. Now, I call upon Sneha Priya Yanappa, Team Lead, Vithi Center for Legal Policy. Sneha Priya Yanappa is a distinguished legal policy professional and scholar, currently serving as Senior Resident Fellow and Team Lead at the Vithi Center for Legal Policy, where she works on urban governance and public law reform in Karnataka. A graduate of Symbiosis Law School, Pune, and a Bachelor of Civil Law from the University of Oxford, she was a recipient of multiple prestigious scholarships, including the J.N. Tata, K.C. Mahindra, and Oxford Law Faculty Scholarships, reflecting her academic excellence. During her time at Oxford, she contributed to Global Legal Scholarship as an editor with the Oxford Transitional Justice Research Group and as a research officer with Oxford Pro Bono Publico, working on issues such as child rights and state accountability. She is also a published author and an accomplished voter. Combining rigorous academic training with impactful policy work, Sneha brings a nuanced and practice-oriented perspective to contemporary questions of governance, constitutional law, and institutional reform. I now invite Sneha Priya Yanappa to share her views on governance, accountability, and human rights.
Very good morning to everybody. Thank you so much for inviting me to the session, ma'am, and a big congratulations to Kilpa for even initiating a conversation, in these areas of human rights. To me, what seemed very interesting was that, we're at a time when India is facing a huge crisis when it comes to heat waves, when it comes to, relief to especially migrant workers during heat waves. And not just this, we have the Disaster Management Act. We have multiple legislations looking at how we're trying to protect the vulnerable from disasters. However, we're still suffering when it comes to actually trying to enforce some of these legislations. To me, that seemed very interesting because I found one particular topic within the theme called disaster management and human rights protection. And a very important question that is often left in the entire conversation around disasters is what happens to the vulnerable. Trying to picture a simple scenario for all of you. It's a very hot day, it's about 45 degrees, and you and I are wanting to go to office and college respectively. And then we get a message saying that, it's work from home today. I'm very happy because I can work from home. You all have a work from home lecture, so you have an online lecture. And you're also happy because you don't have to step out in the heat. But we often tend to forget what happens to those outdoor workers, what happens to the street vendors, what happens to the gig workers. Because while I'm at home at 1 o'clock, when there's scorching heat outside, I also now want to order, a burger for myself because I'm feeling hungry. And I also want the burger to arrive in time because, I'm also feeling very hot and irritable. So the problem that is existing is that we very often forget about the most vulnerable populations when it comes to actual effect of heat. And what I'm trying to say is that when you look at disasters, what's often missing is the acknowledgement that disasters affect different people differently. And to me, that very theme struck hard because nobody really talks about, how heat impacts the street, the street vendors or how, heat impacts the outdoor workers. Because you and I can actually sit at home and work through the day, but they do not have that option at all. And they do not have any other option for that matter because they still have to sell those oranges on that particular day. They still have to come and deliver your food to your house on time. And that is exactly the problem that we have today, even as we speak, because it is still 45, it's still about 30 degrees in Bangalore and we're all sitting with air conditioning in the room. but there's still a huge amount of population that's still suffering from heat outside. So thank you very much for including this, because as we now also work with different governments in India, what's very interesting is governments are actually beginning to think of this as a problem. They're trying to think about what happens to the vulnerable when there is a disaster. Now, fundamentally, to me, the problem was that, when you look at a disaster, you look at an approach that, looks at what happens when a disaster happens, right? So when there's a flood, what do? You try to sort of, look at what kind of recovery can be given to the people who have been affected by floods. When there's a heat wave, you look at what kind of, recovery can be provided to people who have been impacted by heat waves. The fundamental problem is that we're always looking at disasters as a reactive approach. We're looking at this as a problem. When there's a flood, let's see what we can do about it. When there's a heat wave, let's see what we can do about it. But we're not looking at this as a proactive approach to see, can we maybe make the city resilient towards disasters? Can we maybe create guidelines and a framework that will help people already be prepared for disasters? A simple example is this. All of us know that, the heaviest amount of pressure to children and to students particularly is during March, April and May. 3 very hard months of examinations and 3 very hard months for all of us as well when it comes to heat, right? Now the idea is when you're going to a school or college for an examination during these peak hours, you often wonder that, is there an alternative to the scenario? Because we do all, I'm sure, agree that, the weather outside in case of a disaster or in case of an event that is very difficult to bear does have an impact even in our mental health outcomes. Now, this very problem is something that we need to really look at, and to me, the most vulnerable is often missed out in this conversation. I really wanted to sort of, look at how we, of course, don't say that laws discriminate, but society does. Like I said, very important questions that we must ask ourselves, right? Now, when there's a flood, the flood necessarily does not discriminate because it does not see and, on who it on where it should happen, right? But definitely important questions. Who lives in flood-prone areas, right? Which are the areas that are most affected? Who are the people who will be able to get relief right at the first moment? These are some questions that are not really neutral, so to speak, but are very politically and structurally problematic. Second very important question. Who has access to early warning systems? I very well remember, when I was, when all of us, in fact, during the COVID-19 pandemic, were, staying in our houses, trying to make do of, the kind of scenario that we were put in. A lot of people, my house help actually came up to me and she said, if you pray for 4 hours a day, the pandemic will disappear, right? Another person, he came and told me that, if you have these 2 medicines, you will never get COVID in your life. One of the classic things that happened during the pandemic was misinformation. And do we actually look at right to information and right to actual access to information as something that everybody has access to? Now I knew, I took them, I sat them down and I said that this is not how it works. And I also showed them instances where, there is massive misinformation and they could very well be carriers of this misinformation if they did not know what the truth was. And that is how I was able to solve the problem of 2 people. But then I realized that half of the country was actually living in some of these very, very different scenarios of miscommunication. And unfortunately, that is because they did not have access to information in the first place. The third and the most important thing, who receives timely relief, right? When we had, again, in the middle of the pandemic, when everybody was, struggling to get access to hospital beds, not everybody did get access, also because there was a huge amount of population who could not afford, spending that particular amount to get, those beds at the time, right? So again, we're looking at who receives, and these are some of the questions that very often people miss out when they speak about disasters and human rights. One fundamental problem is on the pre-existing inequalities. When we talk about a disaster, we talk about, okay, let's see how this works out for everybody. We forget that there is a certain section of population whose life cannot and will not change no matter what kind of a disaster happens, right? And we also particularly see that there is a lot of institutional weakness, particularly with respect to governance. When I was looking at disasters, and disaster management guidelines in India, specifically with the Karnataka government, again, I do want to mention that governments are now starting to look at this as, a problem and look at this as a problem that needs a solution, and I think that is very important. One of the things that we looked at is, what are the laws that we currently have in India that look at disasters? Now, all of us know we have the classic Disaster Management Act of 2005. A legislation that is essentially fundamentally was brought in to bring in different authorities in the state level. So you have the State Disaster Management Authority, you have the National Disaster Management Authority, you also have a State Disaster Management Plan and National Disaster Management Plan. So the laws and policies are out there. I have to be honest that we have policies and plans in place, but there are multiple questions that all of us must ask ourselves. Are these plans and policies made keeping in mind the most vulnerable? Unfortunately, not. When you look at these plans and policies, the plans and policies talk about issuing, an order, a government order when there's a heat wave. But this government order cannot be the same for everybody, right? When there is a government order that comes out saying that don't come out during hour from 12 p.m. to 6 p.m., you and I can probably be happy about that because we had to stay back at home for a couple of hours. But this privilege is not available for every single vulnerable population out there who still have to be out there because that is their only way and source of livelihood. So to me, the problem is also about how we deal with this particular problem. And third, of course, gaps in accountability. Now, very often, the fundamental problem also lies in the fact that state governments are directly involved in disaster management. But the real unit or the real authorities that should be involved in disaster management are the local authorities. Your councillor, your mayor, your deputy mayor, these are the people who actually know what a city needs at times of emergencies. But very often they're not, because decision making is so centralized, it doesn't really trickle down to the lowest point, and that's exactly a problem when it comes to accountability, right? I have a problem next to my house. There is a huge amount of water logging. Who do I call in this time? A question remains: do I call the authority that is responsible for water and sewerage, or do I call my local authority, that is the corporation? Do I call the councillor, or do I simply call my ward committee that is actually responsible, or takes decisions when it comes to planning within my area? Some of these questions still haunt a lot of us because we're trying to see who can be held accountable. And unless there is accountability, there's never really a question of what can work and what cannot, right? So the next thing that I really want to deep dive is the entire problem of how we look at disasters itself, right? We say it's a natural event, there's an earthquake, there's a flood. But the problem is a disaster is actually a systemic failure of the government to really provide in terms of problem, in terms of hazard. And of course, Article 21, I'm sure everybody has spoken on it at length. And I would also really commend everybody who's spoken about particularly impact of human rights on vulnerable populations, because that is the need of the hour. You will see that we, of course, have these rights embedded within Article 21. There is a right to shelter, there's a right to health, there's a right to environment. But the real problem is how are these rights being implemented, or how are these rights being enforced is a real problem. Like I said, you have food, shelter, health, information. So these rights exist, right? Article 21 actually provides for all of this. It really embeds all of these rights within it. So technically, all of us should have access to information. We should have known what is the impact of, stepping out during the pandemic, or what are the side effects of maybe having a particular medicine. And this is exactly the problem that we now face. And because we're right in the middle of a crisis that we're going towards, there's a need for us to move towards looking at a reactive response to actually looking at a proactive response where you're trying to prepare your cities and its people for disasters in the future. To me, fundamentally, one of the things that I really want to touch upon is on participation. When you want to decide for communities and when you want to decide their rights and responsibilities, it is very imperative for you to involve them in decision-making processes. Our municipal laws that exist talk about creation of ward committees. We have resident welfare associations. We have conversations around, how we need to protect rights of the most vulnerable. The speaker before me, Dr. Durga, spoke about power karmikas, right? Power karmikas are there throughout the day on your roads trying to pick up the dry waste. You have your Zomato and your Swiggy workers trying to get some rest in the middle of the day, but their life is on the road from the start to the end of the day, right? So are we trying to talk to these people when we're trying to make decisions for them? Unfortunately, the answer is no. It is us who, and I'm also guilty of the same. I'm trying to sit down, in my office, trying to see what rights and responsibilities must be attributed to the vulnerable. But unfortunately, if I'm not going to go down and talk to them and see the problems that they face, then very well my participation and my actual allowing them to decide for themselves becomes a problem. The last one, like I said, accountability. Despite the existence of multiple national and state level legal frameworks, what's really missing out is trying to hold a particular authority responsible for what they've done. And that brings me to the next very important aspect in terms of what we have in terms of the laws that exist. And like I said, I touched upon the Disaster Management Act, the National Disaster Management Authority and the State Disaster Management Authority. I should also mention that last year there was an amendment made to the Disaster Management Act allowing for the creation of urban disaster management authorities. Now what this really does is, the NDMA is at the national level, The SDMA is a state level, and then you have the UDMAs, which are supposed to be at the local level, which are actually these are the people who are going to be right at the level of trying to understand what the emergency looks like and try to give you immediate relief. And of course, when you look at the constitutional and international framework, you of course have our Article 21, and under which we have many of these rights embedded. And of course, internationally, we have the Sendai framework, which looks at disaster risk reduction. Now, India is of course a signatory to this framework, which fundamentally would also mean that we do have to work towards trying to reduce disasters. But the idea is also to be able to look at post-recovery. Now, when there is an earthquake or when there is a flood, you look at the impact on people, but very often you do not look at post-recovery processes in terms of the kind of health risks and the kind of mental health problems that people do face. And that particularly is also very evident when it comes to migrant workers who are maybe pushed to go back to their respective homes without really a livelihood, and then you really don't know what happens. I also saw this sometime during the COVID-19 pandemic, and I'm sure all of you would have also seen that there were massive exodus of people trying to go back to their respective towns, walking, right? People were trying to go back from Bangalore to Bihar, trying to walk, trying to find some little space in trains. You had people really crammed up in washrooms. You had people really crammed up trying to I would say trying to find little space in those trains and buses. But the conversation died down after a few days where everybody was anguished in terms of what really happened. But did we all go back to check what really happened to these migrant workers? Were they able to come back to their livelihoods eventually? These are some of the questions that fortunately even the Supreme Court really touched upon. Acknowledging that the migrant laborers were the most impacted because they had to go back, and they had to go back without knowing what their future looked like, right? So the next time when we think about, all of us trying to spend time with family and at home during the pandemic, a thought for the people who really did not have this privilege would be really important. The next thing that I really want to touch upon is, of course, the major theme of this entire seminar, and I think this is something that really is often missed out when it comes to impact of disasters, is the intersectionality and the kind of people who are impacted through the process. One of the major groups who are of course impacted are women, because women significantly face stress during relief camps. You have a lot of increase in gender-based violence. Statistics also show that women face a lot more issues when it comes to trying to recover from disasters, specifically because the same set of requirements that men have, women have a very different, and that is because a lot of times you do not have really hygienic conditions for women to stay, especially when it comes to relief after floods. The second is persons with disabilities. Now, like we said, access to persons with disabilities is also very, very crucial. And when I mean access, I do not mean a ramp, and I do not mean a speech to text converter. I actually mean how are we looking at trying to integrate infrastructural solutions for people or persons with disabilities. And for that, one of the biggest things that is important is for us to acknowledge what are the kind of problems they face. I remember when I happened to visit a public library, in one of the states that I recently went. When we went to the library, and I asked them, I said, what are you doing for persons with disabilities? He said, okay, look, there's a ramp. And that's enough, because, apparently that's what is required. Now, that's the fundamental issue, right? If we were to sit down here in this room and talk about what access means, is ramp the only thing that persons with disabilities want, or need? Of course not, because there are different kinds of people who suffer different, problems, and it's very important to acknowledge what are these issues they are facing and how we're trying to integrate them. There's another, scenario I saw where I went to a park and I saw there was this little children's park that was made, which was only for persons with disabilities. And then I tried to question myself. I said, is this okay for, how does this work? Are we trying to then segregate and exclude an entire population to say you play only in this park? Or are we trying to also wanting to be inclusive to say everybody can, play in this park and grow together, right? Because as children, what really happens is, when we grow up, we want to play with everybody, we want to be able to have that same kind of atmosphere. So the idea of persons with disabilities is definitely not trying to segregate them, but also trying to create an inclusive space of play, inclusive space for study, inclusive space to exist in itself. And the last one, of course, is marginalized communities, and Dr. Durga spoke at this in length in terms of how Paura Karmikas, you have gig workers, you have waste pickers, street vendors who really try to make do of the scenario that they are in. And that is why, the kind of impact that they face during disasters is definitely a lot more in terms of, especially when it comes to, say, lack of documentation that they have, or even in terms of lack of basic services, essential services that they possibly need to have. Now, as two incidents that I just wanted to quickly touch upon before I close. One, of course, the Kerala floods. Now, whenever anybody goes back to the success of local communities and the success of local governance, one state in India comes to everybody's mind, and that is Kerala, because Kerala has really got it right when it comes to effective decentralization. You have the lowest unit in a particular city that knows what its particular area requires, and it essentially ensures that there is effective decentralization to ensure that your local communities are involved in decision-making process. A simple example is when your ward committees, that is the lowest unit in your city, knows what it wants, it lets its councillor know it, and its councillor really decides for what can be done better for the particular area, and then you really can ensure that your city is effectively functioning. But although Kerala was appreciated for what it did in 2018, when there was massive floods that led to the death of over 500 people and more displacement for over more than 12 lakh people, one particular community was unfortunately missed out, and that was migrant workers. Kerala also saw a massive exodus of people leaving from Kerala to their respective towns, not knowing what really the future holds for them. And unfortunately, this is also because in our country there is a lack of regulatory mechanism for protection of gig workers. There is nothing really that looks at what happens to them, in terms of emergencies. If they do not make it, or if they're unwell for a particular day, they lose out the wages for those particular. They don't really have the kind of privilege that you and I have when we're not feeling well, or when we do not feel like we want to go to work. And this is exactly the problem. And because we don't have a regulatory framework, we have a blind spot, and that exactly means you miss out the workers because they actually don't have documentation, so to speak. So to me, the next, and of course, I've spoken at this in length, that, when we speak about the pandemic, we very easily, I remember about a couple of years ago, I used to tell, during the pandemic, I had a lot of time with my parents, spent a lot of time with families because we were within our houses. But I think, I would like to correct myself that now I often do also think about people who actually suffered during the pandemic and, could not really have the same privilege that I had within the four walls of my house. And of course, one of the fundamental problems that the COVID-19 pandemic brought about within itself was reverse migration, right? People actually tried to go back from urban to rural areas, and they did not really know what the future held for them. So that was one of the most fundamental problems. And dignity violations, because, a huge section of population became untouchable suddenly, right? You would say, oh, no, you don't come to my house because maybe you would bring the, you bring the disease along with you. And I'm sure all of us did face this, or did see this at some point in time, that there was an active segregation of who was, so to speak, clean and who was, so to speak, somebody who brought the disease with themselves. And that's exactly the problem that, we have when we look at disasters and how it impacts different people differently. Of course, coming back to my last, 1 minute time, if that's okay. Yeah. So the exact problem with the governance gap, right? What are we doing? The problem is because the state government usually decides what's most important for a particular small city. There's highly centralized decision making, which is the problem. Second, of course, there's a lack of transparency in relief distribution. What really happens is when you're looking at, what kind of relief must be given to a particular population, it's very important for the government to really come out with a social audit that looks at what are the problems and what is the effective solution. Last, of course, you're looking at weak or inaccessible grievance redressal mechanisms. I do remember a lot of people during the pandemic also had issues with respect to access to resources, but really had no real grievance redressal mechanism in terms of where they could go and ask these very important questions that they have, or even ask for relief, or even ask for distribution of essential services. And of course, neglected long-term rehabilitation. All of us looked at the pandemic finished, and all of us are back to our regular day jobs. Of course, a lot of people have had long-term impacts of the pandemic, but there's a huge section of population which has actually lost its livelihood forever, right? So are we as a country also looking at long-term rehabilitation where we're trying to actually audit specific impacts on vulnerable populations, also trying to regularly see what can be done better for them? And of course, to me, 4 very important things that need to happen in this respect. One, of course, trying to embed human rights within the disaster management laws. Now, for me, it's very easy to say, a very broad statement to say we embed human rights, we say that everybody should have access, but that's not what I really mean. It's very important to have effective guidelines that specifically look at vulnerable populations. I do want to give 2 examples here. Various state governments in India have started to look at climate action plans, heat action plans, which are essentially plans that are supposed to guide the local authority when there's a disaster. But unfortunately, the problem with these very heat action and climate action plans are the same. They are very good when they talk about, what needs to happen, but they talk about everybody on the same level in terms of, how heat impacts everybody. They say, when there is, very, very difficult, when it's very hot, don't step outside, right? Now, the don't step outside is not going to work for everybody in this country, and that is why the problem is we don't really cater, our laws don't cater to all kinds of populations, and that's something that is very integral and important to do so. The second one, of course, auditing. Do we really go back to look at, what are the effects of disasters on particular groups? Are we looking at how these groups are trying to recover? Are we trying to look at how these groups are, being rehabilitated or reintegrated into society? Unfortunately, not. And an audit is very essential because it also helps you to see how you can deal with future disasters that are yet to come. Entitlement. Now, very often what happens is there's a disaster, somebody's lost their life. Sometimes there's an ad hoc instance of a compensation. You give them some money, and everything finishes, the story is back to normal. There is a need for, entitlement of compensation. You look at specific disasters and you say when there is a problem, you do essentially, effectively distribute some amount of monetary, assistance to people who need it. And in fact, the 16th State Finance Commission as well has actively given these recommendations to say that, states definitely need a lot more monetary assistance when it comes to dealing with disasters. And the last one, coming to decentralization, like I said, when you vote for your councillor. We don't vote for our prime minister directly, right? But when you vote for your councillor, it's very important for you to decide who you vote because it matters what this councillor does for you, right? So you ask those important questions in terms of, what are you going to do for my area? What are you going to do for my parks? What are you going to do for the public libraries? Those are the very important questions that you need to ask your city mayor, you need to ask your councillor, and you need to ask the people who are directly accountable to you to be able to, really make do for the kind of initiatives and for the kind of effort they can do for your respective area. So the next time, maybe a year from now, all of us will know who our chief minister is, but ask yourself if you know who your city mayor is, because to be very honest, your city mayor is very important for your city, and ask yourself if you know your local councillor. Elections are not yet happened in Bangalore, so I'm not asking you this question right now. And my last, like I said, I really want to end with this one line, but many a times the conversation always revolves around disasters creating vulnerability. To me, it really does not create a situation of vulnerability. It actually reveals and exposes and actually intensifies it. I don't really want to jump into sort of, explaining this, but I just like to, end it in one sentence to say that if there is dignity in life that Article 21 really provides for, I think there should definitely be dignity in disasters too. And I think that's something all of us and everybody else, in this country really deserves. I'm happy to obviously have a longer discussion on this. But thank you so much for giving this opportunity, and thank you so much for wanting to talk on disasters, because disasters and human rights is a conversation that is very, very little touched upon. Yeah, thank you, ma'am. Thanks a lot.
Thank you, ma'am, for your valuable insights. I now invite Dr. C.S. Patil, Director of Kilpar, to present a memento as a token of our gratitude. Now, I call upon Dr. Manjeri Subin Sundarraj, who is an environmental law scholar, academic and practitioner associated with Christ Deemed to be University, holding a law degree from the National University of Advanced Legal Studies, where he held the university second rank, and a PhD from NLSIU. His work on ecological jurisprudence and the rights of nature centers on earth justice, reflected in his book Earth Justice, Developing a New Jurisprudence, and over 50 publications alongside practical experience, including advocacy before the Kerala High Court. A globally recognized voice in the field, he is the first Indian member of the United Nations Harmony with Nature Expert Network, has delivered a keynote at the UN General Assembly, received international fellowships such as the Linnaeus Palm Fellowship, and has lectured at institutions like the Royal Institute of Technology, Stockholm, influencing legal thought on environmental stewardship, animal rights, and the recognition of non-human entities. I now invite Dr. Manjeri Subin Sundarraj to address us on human rights, vis-a-vis environmental rights.
Thank you. Good afternoon. I'll start with a question. What's the average human attention span? I wish, sir.
70, 75 minutes.
Minutes. 10. You're closer, sir. It's 8.25 seconds. Now, why did I tell this? Especially for the very reason that, well, this was one of the main things that popped up in one of the lectures that was delivered by Professor Christopher Stone way back in 1972. Now, he was delivering a lecture on property law. And he found the students not very keen on listening to him. Now, he asked a simple question. Should trees be given standing? Nothing related to property law, unfortunately, but then the question, at least for him, was there in his mind. Because right after he posed this question, the class had a break, and the students obviously forgot about it. So Stone, however, did not forget about it. He started talking about this, and he wrote an article which was published in the Southern California Law Review, 1972, titled "Should Trees Have Standing?", in which he detailed about a lot of things. So just keep this in mind because I'll come back to this later. But the very reason as to why I said this is also because of the fact that at a later point of time, Stone came up with a statement and he said that, well, every single time a new entity is given a right, it's met with either fear or ridicule. I repeat, any time a new entity is given a right, it's met with either fear or ridicule. Why did he say that? That's the point of my discussion. Now, we had a lot of lectures and discussions about how human rights are more important. I asked a simple question. Would human rights be there if our planet is not there? We need to survive. And for us to survive, well, we are supposed to talk about this from a larger perspective. Now, since 2015, if I were to point out, you've had some 400 odd cases which talk about climate change, which bring about aspects of climate litigation, talking especially from the fact that, well, you need to kind of look at it from a human rights perspective. Why? Because we humans have a right to life. We humans have a right to live, enjoy whatever that's there in the environment, and it's all there for us. Talk about any religion, talk about any law. Every single aspect talks about and puts forward this human-centric perspective, an anthropocentric perspective, which I must say is quite right to a certain extent. But then is there something more to it? That's exactly the point that I was trying to make. Now, long time back, you had, as I was pointing out, you had a number of cases which spoke about as to how climate change was one of the biggest threats. And still today, I think it's still one of the biggest threats that we as a human race do face. You've had numerous cases that have been filed in umpteen number of countries which specifically talk about climate change and the way in which we, the current generation as well as the future generation, is supposed to look at it. For example, there was this case that was filed by a group of children, I think it was in Germany, way back in 2021, when they said that, well, we need to kind of ensure that climate change is to be done away with, that every single step has to be taken so as to ensure that, well, climate change, the after effects of climate change has to be mitigated. Why? Because we are the future. All those legislators, sorry to say, are old. You'll die, say, in 10, 20 years. What about us? We may live, say, for another 50, 60 years. Are we supposed to look into are we supposed to deal with all these problems at that point of time? Well, sorry, we are not going to. Unless, of course, you take the step right away. And talk about all these legislators, all these laws that are being made. Well, are you not supposed to take into consideration that the fact that, well, we as a future generation do have an equal right, if not more, than what each one of you do have? Your lifespan is limited. We have a lot of life in front of us. And that needs to be protected, was one of the arguments that was raised by the children, so as to say. And taking clue from these simple cases that were filed in different countries, Well, I'm talking about the intersectionality of human rights and environmental laws, environmental rights per se. Now, even if you were to kind of look into all these legislations and all these cases that were filed in various countries, well, sorry to say, many of these countries did not buy this argument. Some even went to the extent and said that, well, there's no point in us really talking about this sort of a right because of the fact that for us right now, human rights are more important. And we need to talk about as to how human rights are to be protected. I'll give you a simple example. Article 21. What does it say? No person shall be deprived of his life or personal liberty, save as exit provided by law. Do we have, say, the right to live in a healthy environment as part and parcel of the original text? Absolutely no. At different points of time, you've had courts, the Supreme Court as well as various high courts, read into Article 21 many of these rights. And the speakers before me detailed a number of cases which spoke about as to how Article 21 is so looked into and kind of, I would say, beaten black and blue so as to include each of these rights, of which the right to live in a healthy environment is also one. The right to environment. Again, I do have a problem. We're talking about human rights. We're talking about right to environment. Whose rights are we talking about? Yours, mine, ours. What about the environments? Why not we talk about the right of environment? Why did we not speak about it? Why did we not even think about it? And that brings me back to the sentence that I did point out earlier. Is it met? Are we meeting it with fear? Do we fear giving the environment some sort of a legal entity status? Are we kind of jokingly looking at it, saying that, well, how do you give, say, the environment some sort of a legal status? It isn't a living being like you and me. But then are we not missing the whole point? If the environment doesn't exist in the way in which it should, well, I, me, you, no one would exist. Now that, unfortunately, my friends, has not been looked into a number of instances. You have had cases in various countries, Indian as well as foreign, which speak about this specific aspect. And there have been instances, for example, in Belgium, there was this case that was filed by another set of children who spoke about this sort of a right. The court was very particular because of the fact that the children had said, well, we need to arraign a tree as one of the litigants along with us. Because why? The tree also had a right. Court said nothing to it. No. A blatant, on the face, no. And then they kind of dismissed the suit. There were also other instances wherein courts have said, why don't you exhaust all other remedies and then come in front of us? Why do you want to come to us, the highest court, and then ask for these kind of rights? Which, I must say, the court poignantly said are simply not going to happen. One of the earlier speakers also spoke about, just a little bit out of context, but then she also spoke about the way in which, say, international humanitarian law, especially refugee law, doesn't take into consideration environmental concerns. I cannot, say for example, be a climate refugee. Why? Because the Refugee Convention, specifically the 1951 Refugee Convention, specifically says that, well, I can only be a refugee if there is a persecution, if I fear a persecution if I were to go back to my country of origin. Which means that it's political in nature, not environmental. So environmental rights, human rights, as I said, my friends, are not two distinct aspects which need to be looked at from diverse perspectives. Rather, it is, I would say, those are two perspectives which are to be looked together. And you have had different aspects of looking at it as well, which unfortunately, I must say, is not on the right path. Why? As I did point out earlier, we are speaking about human rights as one, I would say, one chamber, and environmental rights as a completely different chamber. And you give a little bit more of a thrust to human rights and say that, well, as humans, we need to protect our rights because of the fact that, well, that's more important. The right to live in a healthy environment. As I did point out earlier, Article 21. Now, taking clue from some of these aspects, I would say that, well, even in India, when you talk about Article 21, courts have been reluctant to kind of give a little bit of an importance, say, to natural entities. It spoke about as to how, say, nature need not be treated to be as a specific legal person. Now, time and again, there have been difference of opinions. Now, one such instance was a judge. His name was Justice Rajiv Sharma. He happened to be a judge of the Uttarakhand High Court, and then later he was transferred to the Punjab and Haryana High Court. But then he delivered a few judgments in both these high courts. And one of the earliest judgments that he did give was the fact that, well, he gave legal entity status to the Ganga and the Yamuna, saying that, well, these are living persons and have rights just like you and me. Then he made a simple mistake. When he said that, well, these legal entities need to be given some sort of a right, the term that he did use, or rather the phrase that he did use, was the fact that, well, rights, duties, and liabilities that exist on humans would be given to these natural entities as well. Now, that, my friends, albeit the fact that it was a judgment which opened a lot of eyes, was a simple mistake that this particular judge made. I'll give you an example. Now, when he said rights, perfectly fine, giving rights to national entities, I don't care. They should be given rights. Now, the problem starts when you impose duties and obligations. A river. I have a nice riverfront mansion. The river floods, enters my house. If the river has duties, as was pointed out by the judge, I can file a case against the river. How dare you enter my house? Should not a liability be placed? The judge said so, not me. Rights, duties, and liabilities are to be placed on, say, natural entities. Do we have a problem? Absolutely yes. The river can also make a counter claim. You built your house on my banks. You encroached my area. Which means that, well, contributory negligence. I was not negligent. You came inside my area, and that's the reason I flooded. You should not have been there. Which means that it opens a can of worms. Which means that, well, the aspect that you're supposed to give some sort of a duty or a liability being placed need not be actually placed on a natural entity. Now, the point that I was trying to make is the fact that, especially when you talk about this juxtaposition of human rights and environmental rights, I think there needs to be some sort of a balance. The very reasons to why we talk about human rights is because of the fact that we humans think of ourselves as superior. Think of, say, a pyramid. We place ourselves on the top. And that's the reasons why, take any law as a matter of fact. You kind of understand that, well, laws are inherently anthropocentric in nature. We care for ourselves. We want all these laws to cater to our needs. And that's exactly the reason as to why we read Article 21 as the right to live in a healthy environment, right to live in a healthy environment. Now, if you were to slightly change this perspective and think about a circle and place all these entities within the circle, well, I think we are equally placed. And when I talk about us being equally placed with a number of other entities, I think we are not giving some sort of a prerogative to anyone. And in this case, we are not giving a prerogative, say, to humans. I'm not against human rights. I'm just telling that, well, there needs to be a difference in opinion in the way in which you're supposed to conceptualize human rights. Simply because of the fact that, well, if you were to cater to only human rights without catering to environmental rights, well, sad to say, you won't have any humans anymore. And there's no question of human rights arising at that point of time. So it's a way in which you're supposed to balance both these aspects and take into consideration the fact that, well, unless, of course, we balance these and iron out all these differences that are there, things are not going to be rosy henceforth. Which takes me back to the first statement that I did make. Stone statement. Anytime a legal entity is given, Anytime an entity is given some sort of a right, it's either met with fear or ridicule. It's high time that we kind of get rid of it. You don't have to fear it. And obviously, you don't have to kind of ridicule it as well. Why? Because this is something which I would say caters to a better protection of human rights, all said and done. By protecting the environment, I would say we are protecting ourselves. I mean, as selfish as it may seem. But at the same time, we are protecting not only ourselves, but then we are protecting all those other entities that are there as well, living as well as non-living. Should that not be some sort of a mantra which we as humans, given our superiority, at least I would say on paper, is that not what we expect ourselves to do? Think about it. We call ourselves the most developed. And yet, we are the only species who kind of destroy the only place that we can live on. And yet, we call ourselves the most intelligent. Now, given the fact that, well, this is how you're supposed to look at things, I mean, things are not so dark as it may seem. You have numerous countries. Now, India, as a matter of fact, I will talk about the High Court judgments, which did give a legal entity status to a number of rivers, mountains, etc., etc. But then, unfortunately, there was a Supreme Court decision that was laid down in People's Charitable Organization versus the Union of India. And the Supreme Court said nothing to it. We cannot give some sort of a legal entity status to non-human entities. That's what it currently stands at. But then despite that, we've had numerous instances where in other countries, say for example, in Ecuador, for example, that was one of those countries which does have in its constitution some sort of a right which the environment does possess. Bolivia is another country which has a specific right as part of a law which says, well, nature should be treated as some sort of a legal entity. You've had umpteen number of instances, even say New Zealand, they have given rivers rights, just like you and me. Bangladesh has certain rights. They are giving all rivers within the country of Bangladesh such rights. And roughly around 50 to 55 countries across the globe have these rights of nature being instituted or incorporated in their laws. So my point being, as a matter of fact, to conclude, human rights all said and done, I would definitely say yes. But given the fact that we have an added responsibility because of evolution, because of the fact that we are a bit more evolved than all other entities, and we do have what it takes to bring about the change. I think it's high time that we talk a little bit about environmental rights also within the same breath, and talk about and understand that, well, human rights means nothing if you don't take into consideration environmental rights. Thank you so much.
Thank you, sir, for your valuable insights. Now, I invite Dr. C.S. Patil, Director of KILPAR, to present a memento as a token of our gratitude. Now, I call upon Jyotika Randhava, Senior Resident Fellow, Vidhi Center for Legal Policy. Ma'am is a Senior Resident Fellow of the Vidhi Center for Legal Policy, where she works with the Justice, Access and Lowering Delays in India initiative, focusing on judicial reforms and improving access to justice. A graduate of ILS Law College with a master's degree from the Tata Institute of Social Sciences, she brings a strong interdisciplinary perspective shaped by her extensive fieldwork within the juvenile justice system. Her work lies at the intersection of law, research, and policy advocacy, with a particular focus on criminal law, criminology, and human rights. She has authored and contributed to several influential research reports and policy papers aimed at modernizing India's civil justice system, including work on case management, judicial delays, and procedural reform. Combining empirical research with policy-oriented solutions, Jyotika Randhava's work continues to contribute meaningfully to ongoing efforts to make India's justice delivery system more efficient, transparent, and accessible. I now invite Jyotika Randhawa to share her insights on criminal justice and human rights.
Thank you. Good afternoon, everyone. So one of the subtopics today is institutional accountability in the criminal justice system, and I thought that since police is the first point of contact for a lot of people dealing with the criminal justice system, we could look into police accountability and prospective reforms. So when we say institutional accountability, the first question that pops to mind is what does it mean? It means mechanisms that ensure that institutions uphold the rule of law and are answerable for their actions to the public. Now, we say public because, in case of the police, accountability to the state and the executive has not exactly translated into accountability to the people. So, just to probably look at data for instance, the Global Torture Index characterizes India as high risk when it comes to human rights violations by the police. In all our day-to-day life, you've probably heard about and read about several instances of violations by the police via anecdotes, via media reports, etc. Yet, as per official sources, the numbers do not look as alarming. If you see here, we have the data by the National Human Rights Commission, which is empowered to take complaints against police officials and to inquire into human rights violations and to provide remedies. So if we look at the data here, we see that as per NHRC annual reports, in the past 4 years, complaints against human rights complaints against police officials have hovered roughly between 100 to 200 per year. Now, does that mean that the situation is not as grave or dire as it seems? To that, I'll say that before we arrive at any conclusion, we should first look at what the data is not saying as much as what the data is saying. Because if you look at the graph here, you can see that it is only custodial deaths and rapes that are basically captured by NHRC data. If you look at NCRBs as well, which is the National Crime Record Bureau that records, that keeps a record of offences committed within India, that will also only records custodial deaths that occur in police custody. So at present, what we see is basically there's a dearth of official data, there's a dearth of disaggregated data that captures other human rights violations like grievous harm, illegal detentions, unlawful arrests, etc. Now, what this does is it underrepresents the true extent of the problem and it makes it difficult to advocate for change. Now, why do you want to advocate for change? Can be the next question. Because currently we do have accountability mechanisms in place, but as we are about to see, these mechanisms suffer from various structural infirmities which require heavy rectification. So we have two kinds of accountability mechanisms, internal and external. When it comes to internal mechanisms, what we are looking at is basically police department inquires into complaints of misconduct by the police. This is by virtue of, just for law students, to give a legal framework, this is by virtue of Section 7 of the Indian Police Act or equivalent provisions in the state laws that empower senior officials to discipline juniors. Senior officials in turn are governed by the All India Services rules where the state can discipline them for misconduct. Now, what we see in disciplinary proceedings, unfortunately, is that it is characterized by a high level of opacity because the outcomes and the procedures are largely confidential. Because of that, whatever data we have is at best fragmented, and there are no nationwide statistics which look at the complaints that are received by internal disciplinary departments, the inquiries conducted, the types of misconduct that is being complained of, and the outcomes or decisions rendered. There's also a general perception among scholars that when it comes to internal departmental inquiries, there is an in-group bias that comes into place, and they're often rendered ineffective because there is a tendency to suppress information to prevent reputational damage. So that is for internal accountability and the issues that these mechanisms face. We also have external accountability mechanisms in terms of judicial remedies, in terms of the National Human Rights Commission, and in terms of another independent body that was established called the Police Complaints Authority. Now, when it comes to the judiciary, it has often intervened to address human rights violations committed by the police under Articles 21 and 22. Most of you would have studied the landmark case of Rudal Shah versus State of Bihar, where the SC held the state liable to pay compensation for illegal detention of an acquitted person. Now, after that, there were a slew of judgments that followed, where the court held the state liable for violations by the police, human rights violations by the police. But in the case of Subeh Singh versus State of Haryana, the SC put into place a principle that effectively limited this public law remedy to instances where the violation was gross and of a magnitude that shocked the court's conscience. Now, what that means is that public law remedies currently are limited to serious misconduct by police: custodial death, rape, torture, forced disappearances. But mere instances of illegal detention, unlawful arrest, etc., cannot be covered for compensation under public law remedies as of now. Civil law, sure; public law, not. Then there's another aspect that comes into place, which is criminal law liability for misconduct of the police, where people can approach courts for offences committed by the police, such as illegal detention, illegal confinement, harassment, etc. But then also we might know that there is a section within the BNSS, section 218, which prevents, which basically says that the state has to authorize any prosecution of police officials, and that is there for most offences. Another serious infirmity that the criminal law remedy sort of suffers from is that the police itself is investigating complaints and their own violations, which is not a very independent procedure. And as can be evidenced by the fact that there are very few offences committed by the police that actually get judge-sheeted at the end. And there are very few convictions actually in the history of India's entirety since independence. Now there's another framework where people can go to for human rights violations by police, which is the National Human Rights Commission. The NHRC, while independent, has only a recommendatory authority or power. It can only recommend the government to initiate departmental inquiries or prosecution against the erring police officials, and then it is up to the government to take action. Now, to account for all these issues, the Supreme Court directed in Prakash Singh versus Union of India that independent bodies be set up across all states to look into complaints of police misconduct. These were to be called as the Police Complaints Authority, and while at the state level, the authorities were to be set up to look into misconduct by officers of the rank of Superintendent of Police and above. The district level were to be set up to look into the complaints against much junior officers. Now, while a great idea in principle, the implementation has been very dicey and it has been very inconsistent throughout. There's a great report by Commonwealth Human Rights Initiative that basically looks at that documents the issues faced in the implementation of this Supreme Court directive. Not least being that while this directive was supposed to be implemented by all the states, 2 states have, as of 2023, yet not provided the legal framework for setting up PCAs. For other states, 26 states have provided the legal frameworks. They have actually amended laws and passed executive orders, which is commendable. But then again, if you see the on-ground implementation, there are only 11 PCAs that are actually operational as of 2023. PCAs in other states are either yet to be set up or they are non-functional because of the failure of the state governments to appoint officials. Another issue that we sort of face is basically in the composition of the PCAs where it has been set up by the states. 9 states, basically in complete contravention of the Supreme Court's directive, have serving government officials and police officials in their PCAs. Now, this is completely contradictory to the Supreme Court directive, and it also basically defeats the purposes of setting up an independent body to investigate complaints, because it is again the police that is investigating complaints against its own officials. Now, only as with respect to the investigative procedure, only two states, that is Assam and Tripura, have actually set up independent investigation cells. Rest all investigations before the PCA are actually still being managed by the police itself, which is again sort of defeating the purpose of setting up an independent body. Now, another thing that PCA has in common with the National Human Rights Commission is that basically it only is able to make recommendations to the government to initiate proceedings or to prosecute the police officials. And as per the Supreme Court directive, while the recommendations were supposed to be binding, they are actually in reality very poorly implemented by the governments. And several of the PCAs have actually called out governments in their annual reports about the fact that these recommendations have not been implemented. But one final thing with respect to PCAs is, while a good initiative, there is a need to ensure that there is transparency in the working of PCAs. Because as of now, there's a dearth of data. There are very few PCAs that actually publish their annual reports. I think Karnataka is one of them, so actually kudos to Karnataka for doing that. And because there is very few information on, the disaggregated data on the kind of complaints received by them, the kind of misconduct that is complained of, the kind of inquiries, the number of inquiries conducted, the decisions rendered, the reasons for the decisions rendered, and the follow-up at what has been recommended to the government, whether the government has followed up with that recommendation or not. There's basically very little to go on off when you want to see how effective PCAs have been. Now, basically, just to conclude, what do we need in terms of policy recommendation? I'd say first we need more data. We need more official data, we need more disaggregated data, and we need it from all the public institutions that are actually responsible for holding the police accountable. We need it from the judiciary, that as of now does not actually provide disaggregated data on human rights violations. So for instance, writ petitions that have been filed for human rights violations, for habeas corpus petitions that have been filed for human rights violations, criminal law actions that have been taken for human rights violations by the police, that data disaggregated is not provided by the judiciary. Police authorities need to make at least, so this is something that we demand from a lot of, from the courts per se, that they need to make their internal disciplinary mechanisms transparent. And that is something that police also needs to do. We're not asking for personal data, we are asking for basically information on how many complaints have been received by them, how many complaints have they acted on, and in case where they have imposed a sanction on the police official, then those orders need to be made public. We need data from PCAs, we need more data from NHRC, which needs to put into the public domain what kind of complaints it has received, apart from custodial death and rapes, and what kind of recommendations it gives for that. Now, what do CSOs do? So, a lot of CSOs are actively involved. We can actually file RTIs, and you as students also can do that. Basically, it is a tool in our arsenal that we can employ, because all this information is not personal information. It is available. If you file an RTI, you can get that. And that is something that CSOs should work towards. If official data is not forthcoming, then we need to put our heads down and actually apply through RTIs to get more data and put that into public domain. Another very important thing that needs to happen, and a very practical recommendation, is that we need a truly, and I mean this has been put forward by a lot of people, but we need a truly independent disciplinary body that is empowered and has the resources to independently investigate the police and to impose sanctions on them, and not just provide recommendations. Now, of course, this would need actually, because this is a state level subject, this would need amendments of state laws per se, but this is something that is the need of the hour. To ensure that the body actually remains independent, though, transparency is non-negotiable. As I have already pointed out before, we need transparency as to how the members of this body are appointed, who are the members, how they are appointed, what are the rules and regulations that these bodies follow, and we need reasoned publication of reasoned orders by these bodies. Finally, as a lot of people before me have said, for actual on-ground change, we need a demand from the public for reforms. And as such, I feel like police reforms are actually at the lowest rung whenever we are looking at any elections, any demands from public officials. It's usually more police, women's safety, etc. But if we do not improve the accountability mechanisms, then those things are also not going to actually come into place. So for actual on-ground change, the public needs to stay informed, the public needs to care, and the public needs to demand change, and only then will the state and the executive follow. Because as we say, if the rights of if the rights of all are not guaranteed, then the rights of none are guaranteed. So thank you.
Thank you, ma'am, for your valuable insights. Now, I invite Dr. C.S. Patil, Director of KILPAR, to present a memento as a token of our gratitude.